Okay, I'm gonna switch. It's running right now. Um, John, you are the host now.
Anna, are you there?
Yes, can you hear me?
Yes, I can. Perfect. Yeah,
Oh,
sorry.
sorry.
I
I have
wasn't.
my phone, I didn't realize my microphone was off.
Oh, yeah, no, you're good. I wasn't
Okay, now
actually
you're
by
the
my.
host. I'll leave in a minute. You're now the host.
Okay. And so that was my question. So you've made me the host. We're on YouTube. You don't have to stay on in order for us to stay on YouTube.
No,
Okay.
I only will stay there until I finish doing what I need, just in case I need to reconnect. I don't
Uh-huh.
believe I will.
Okay.
So when I finish posting the Zoom, the YouTube link on the website, then I will log off.
Okay. That sounds good.
And then when the meeting keeps running until the live streaming keeps running until you end the meeting.
Got it. All right.
Mhm.
That's perfect. Thank you. Appreciate it.
Sure.
Check, check. 1, 2, 3.
Yeah, I can hear you. Can you hear me?
I can. Good. Cool.
Good morning, Ms. Gonzalez. Can you hear me? Ms. Gonzalez, can you hear me? I saw you just for a second. Perfect. Sounds good. I can't hear you, but I can see you. Yeah, still can't hear you. Yeah, isn't it? Yeah, Ms. Gonzalez, I'm still not able to hear you. I'm going to step away from my computer just momentarily.
Oh, yeah, I did,
Let's try it again.
but yeah, no, I see it.
1, 2, 3, 4, 5.
Okay, but I need them to hear me. Does that mean they'll hear me?
This is our testing. If it's any different than when you're real
Oh, but
time,
why should I hear that in here? I normally don't hear me when I'm speaking in here,
because it's a test, similar but different.
but I need.
If you're
okay.
supposed to test with you, what good would it be if you can't hear yourself? That's one where it does work.
Well, I never hear myself usually, usually,
Well, when we see, okay, we have microphone real tech, which is the computer mic.
right?
Isn't that the one? Because this is all hearing. There's no microphones here
Oh, okay.
in this web.
Okay.
If you don't hear, you just come down and I don't think you got hearing on this because it wants to simulate that USB. You don't have a
Just leave
US.
it, and I'll get on and see if something.
You don't have USB, and that's just a kind of a combination of that, but I think you're gonna be really just on the real tech of the computer mic.
Okay, well,
Do you know what the test is? The test is for you to do it independent of anybody.
everybody, if this is recording. How about now? Oh, good.
Perfect. I can hear you now.
Oh, Lordy. I just don't need this 5 minutes before we start. You know, oh, I look like a disembodied body. I had done an in-person and I have to use the same computer because it was a hybrid. So some of us were in
Oh,
person,
okay.
some were remote, and it's different setup. And so I was
Yeah.
trying to get it back. And I have a paper around here somewhere with all these different ways I set it up, and of course I can't find it.
Hmm.
Good morning.
Hey, how are you, Melissa?
I'm doing well. How are you guys? Oh, let me
Good.
shut the door. really
John, is
quick.
that new headset?
Yes, it
that the-
is.
yeah,
Mhm.
Is it good?
Okay. I'm
Yeah,
gonna
it's good.
start.
It's the only thing about it is that I haven't gotten used to, like, my voice sounds weird to me because I think
Yeah.
they're noise canceling headphones.
Yeah.
So like,
That- Right.
I can't hear myself the way I normally do. But other than that, so
Well, and I think the mic actually, there's stuff going on in the mic where it's going to try to, what do they call that? Like Vox, right? Where like it only picks up certain sounds, not ambient noise, right? Because if it's too sensitive and it picks up like the sound of your refrigerator in the background, I think some of these
Yeah.
devices actually cancel that out, which is kind of impressive. I don't know if that's the case, but
Yeah, I think Zoom lets you do that, guys, under the carrot.
well, like the fancy mics, like I remember what was a P&M proceeding, and Rick was there, and he showed us his mic, and they have a real nice mic, as you might imagine. And those things will actually like can distinguish between what is a voice and what is just ambient noise, and then only brought that. And I guess air traffic controllers use that exact technology for obvious reasons.
I should be outputting to the real time for you guys.
yes, I have it. I have the real time pulled up right now.
Oh, okay. Well, I did my homework, so if I can just. All right. Making sure.
Hearing examiner Ryan, I have 8:58. I've got about 8 people waiting to come in. I
Yeah.
think
You
it's
can let
everybody.
Can someone forward me the real time link again?
Yeah, I'll do that now. And I'm admitting everyone now, just FYI.
Fine. Yeah.
Okay, hearing examiner Ryan, I just forwarded that to you.
Cool. There we go.
Okay, I think we have everybody. Yeah, I think we have all the parties. Before we go on the record, is there anything that the parties want to address off the record? Okay, not seeing anything. Then Ms. Gonzalez, then I think we're ready to go on the record.
Very good.
Okay. Good morning. We are now on the record. In this matter before the New Mexico Public Regulation Commission will please come to order. This is the time and place set for the evidentiary hearing in the matter of El Paso Electric Company's application for approval to implement a time varying rate pilot program, docketed as case number 24-00113-UP. My name is John Kreinkamp. I'm joined this morning by Christopher Ryan. We are the hearing examiners with the New Mexico PRC assigned to co-preside over this matter. This hearing today is being transcribed by a court reporter. For the sake of that record, I'd like to start with entries of appearances from the parties, starting with EPE.
Good morning, hearing examiners Carrie Olson for applicant El Paso Electric Company, and attorney Nancy Burns, in-house counsel for EPE, will be joining me for parts of the hearing.
Excellent. Good morning. PRC staff.
Good morning. My name is Ryan Friedman, representing PRC Utility Division staff today.
Good morning. And the New Mexico Department of Justice.
Good morning, Mr. Hearing Examiner, Gideon Elliott for the NMDOJ.
Good morning. And last but not least, Mr. Salen, I believe on behalf of the Coalition for Clean Affordable Energy.
That's right. Good morning, Mr. Hearing Examiner, council and parties. Charles DeSalen, representing Coalition for Clean Affordable Energy.
Good morning. Good morning to all the parties. Thank you all for being here this morning. At this juncture, I'll just note for the record that there were no individuals or entities who signed up for public comment as provided by the procedural order, so that is not something that will happen this morning. At this stage of the proceeding, the parties have agreed to and filed an unopposed stipulation along with supporting testimony and a briefing statement for CCAE. The email that EPE sent to the hearing examiners and the service list earlier this week stated that the parties intended to waive cross-examination, of course, still retaining the right to ask questions based on the questions posed by the hearing examiners and the commissioners, if any attend today. Is that correct?
That's correct from EPE.
Okay.
Yes, for the Attorney General.
Yes, from
Okay.
staff.
Yes, from CCAE, we've waived cross.
Okay, excellent. And the email from EPE also generally outlined the following for an order of witness examination, starting with EPE's witnesses, Mr. Novella and Mr. Carrasco, followed by the DOJ, Ms. Courtney Lane, and then last, the staff's witness, Mr. Christopher Dunn. I'm assuming that everybody's agreeable to that. Are there any preliminary matters or questions from the parties that we need to address before we begin the hearing today? Okay, seeing none, there is one preliminary issue that hearing examiner Ryan and I had, and I think this is going to be primarily for EPE, although I'll probably ask the other parties to weigh in. When we were going through again EPE's initial application, as well as Mr. Novella's direct testimony, there appears to be an issue where advice notice number 299 was supposed to include both original rate 48 and original rate 49. But it appears that it included 2 copies of rate 48, which I believe was for residential, and not rate 49. I wanted to give the parties to weigh in on that. Is that an issue for us to address? Is that going to be a problem today? EPE, I'll give you first bite at the apple on this.
Yeah, EPE actually filed a notice of errata on April 1st, providing an errata version of GN1 to correct that issue that you've raised. And the version of Mr. Novella's direct testimony that we uploaded to Dropbox incorporates the errata exhibit, and so that should be corrected.
Okay. Anything further on that issue, hearing examiner Ryan?
No, I mean, it's the advice notice process, if I understand correctly, is, the 17 something we were looking at this other day, it provides when the application is filed, it's to include an advice notice. And then it says something to the effect of, has to be forwarded to the Attorney General's office. And if I understand what those rules are attempting to achieve is, the advice notice is providing notice to both customers and the necessary parties about what is the nature of the request. And I'm aware that, oftentimes in cases we end up filing amended advice notices after the fact because changes occur. But the basic question was whether there are any of the parties have any issues with what went down, and then the answer may very well be no.
Sorry, can I just address that, because I misunderstood the question. So I thought hearing examiner Krankamp was talking about the exhibits. If you're talking about the actual advice notice, EPE did separately file an advice notice following the process that that hearing examiner Ryan has pointed out with PRC records. And the advice notice did not contain the same error that the exhibit contains. So the error that you pointed out is solely an error in Mr. Novella's testimony. It did not impact the actual advice notice that was filed with the commission. And then just one other kind of minor point on that we'll get to in the hearing, but as part of the stipulation, the parties have asked the commission to order that original advice notice to be withdrawn and to provide EPE an opportunity to file a new advice notice incorporating the revisions to the rate that are addressed in the stipulation.
And it looks like Melanie Sandoval and company and then part of this is kind of interesting when these things happen because it makes you focus on the processes. You provided the advice notice with the application to Ms. Sandoval, but that's not, at least on the PRC's website, uploaded. And I'm guessing she probably uploads that into the company's advice notices the commission keeps after the case is completed or final action. Do you know, Ms. Olson?
Yeah, so it's a complicated process, and I think in the past EPE attached the advice notice to their application, and Ms. Sandoval and records would file that separately, and they specifically asked us to stop doing that. That it's okay to include it as an exhibit, but we need to file the advice notice separately with PRC records. And then my understanding of the process is there is a place in what was formerly eDocket, I forget what it's called now, where you can access the filed advice notices, but they don't get reflected on the commission's website until they get that effective stamp on them.
Final commission action.
Mm-hmm.
That's interesting. I wasn't aware that eDocket had a place where these things get preliminarily deposited.
Yeah, it's a search function where you can search for filed advice notices, and so everything that's been filed is in that. But Ms. Sandoval's walked me through it before, and I cannot remember off the top of my head how you do it.
Okay. All right, great. Thank you.
All right, and I guess just to finish that issue, any objections from the parties on that issue where we stand, and as Ms. Olson has outlined how the company's handled that? Okay, seeing none. With that, that's the only preliminary issue that the hearing examiners had. So I think at this point, we can move to testimony, and EPE, you can call your first witness.
Thank you, hearing examiner. EPE calls Mr. George Novella as its first witness.
And Ms. Gonzalez, can you swear in the witness?
Sure. Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Please proceed, Ms. Olson.
Good morning, Mr. Novella. Can you please state and spell your name for the record?
Yes, George Novella, N-O-V as in Victor, E-L-A.
And Mr. Novella, what is your current position?
I'm the Director of Regulatory Policy and Rates with El Paso Electric.
And because we're here today on the stipulation, I'm going to start with your supplemental testimony. Do you have before you what's previously been marked as EPE Exhibit number 1?
I do.
And do you recognize that document as your supplemental direct testimony in support of the unopposed stipulation?
Yes,
Was that supplemental testimony drafted by you or under your direct supervision?
it was.
And are there exhibits identified on the table of contents as part of your supplemental testimony?
There are.
Do you have any corrections to your supplemental testimony?
I don't.
And is the supplemental testimony that you prepared true and accurate to the best of your knowledge and belief?
It is.
If you were asked these same questions today under oath, would you give the same responses?
I would.
Mr. Hearing Examiner, EPE offers EPE exhibit number 1 along with accompanying exhibits.
Thank you. Any objections as to the offered admission of EPE Exhibit 1? Seeing none, EPE's Exhibit 1 is admitted into the record.
And Mr. Novella, I'd like to move now to what's previously been marked as EPE exhibit number 2. Do you recognize that document?
I do.
And was that direct testimony drafted by you or under your direct supervision?
It was.
And are there also exhibits identified on the table of contents as part of your direct testimony?
There are.
And then, as I mentioned previously, for the record, Mr. Novella's testimony does incorporate the changes to his exhibit GN1 that were provided in the April 1st notice of errata filing to substitute the copy of original rate number 48 for the rate number 49 rate schedule. Do you have any additional corrections to your direct testimony?
I don't.
Is the direct testimony that you prepared true and accurate to the best of your knowledge and belief?
It is.
If you were asked these same questions today under oath, would your responses be the same?
They would.
And Mr. Hearing Examiner, EPE offers EPE exhibit number 2 along with the accompanying exhibits.
Any objection as to the admission of EPE Exhibit 2? Being none, EPE Exhibit 2 is admitted into the record.
Thank you. That concludes my direct examination. I'll pass Mr. Novella to the hearing examiners and any commissioners for questioning.
Thank you, Ms. Olson. The parties have waived cross-examination. So at this point, and I don't see any commissioners on the call, at least not as of yet. So Hearing Examiner Ryan, any questions for this witness?
Yeah. I mean, I think I just want to say preliminarily, and the nature of the questions are such that, I've just spent the last 3 years of my life working on PNM's grid mod case. And, when you sort of look at the broad scheme of like, where we were back in 2006, when the first instance of a question about PNM's advanced metering program was first asked, and it's 18 years ago, to where we are now, there's a tremendous shift. And part of our job as the hearing examiners in these cases is to try to bring to light matters that are, sort of macro level questions that commissioners are going to invariably have. So I'm fully aware that the stipulation here and parties are all in agreement, but it's our duty to also go and probe and bring to the discussion the stuff we've learned in the course of the cases we preside over. So that's the nature of the questions. So Mr. Novella, does EPE, and if this is in the record, you can tell me, well, you don't need to, but in your Texas jurisdiction, does EPE have time of day rates?
We do.
And so if that's the case, I have to presume that what you've learned in your Texas jurisdiction as regards, how customers behave and what is the sort of best practices for the company. I mean, are you bringing that to bear on this application for the time varying rate here?
I think we're definitely bringing all in our internal knowledge that we have, but the way I see this pilot is we're going much beyond that. As we brought in the Brattle group, and based on the stipulation from the final order of the AMS case, we're going well beyond anything that we have currently in either of our jurisdictions.
Okay, yeah, all right, great. So one of the things I noted repeatedly in staff's testimony, I think it was staff, might have been AG. Well, and anyway, it's not important. And I don't mean you use these words in a judgmental way, but like the customer response to time of day rates has been anemic. Is that fair characterization?
Can you define response? Do you mean like participation levels, or
yeah,
the ones
exactly, participation levels?
I believe they're low. They're not material by any means in terms of customer count currently.
Is that also the case in Texas?
They're low as well.
So, I mean, I guess that's why. Like, why do you think that is?
Well, I think that goes outside the scope of what we're doing here. I'm not familiar as much with the marketing campaigns. I know we've done quite a bit of marketing around these types of pilots. If you go to our website currently, we'll be highlighting these types of rates. But generally, I can say that nationally, I've seen that trend that you've described where enrollment counts are fairly low for time of day or time of use rates. Our witness, EP witness Carrasco, the manager of rates, may have more information regarding participation levels.
Well, I'm not sure it goes outside the scope because I mean, I think right, you know, in the P&M rate, in the P&M grid mod case, I had to answer two arguments. Number one, AMI is illegal. And number two, time of day rates don't have any impact on customer behavior. So, you know, you can have whatever thoughts you want about the nature of those questions. But you know, my reading of the statutory scope or the long scope of the history of the Renewable Energy Act and where grid mod and TEP and all this stuff fits in a big picture is we need to be moving towards a paradigm where customers understand consumption questions have moved from a how much to a when, and then fundamentally make them actually do the load shifting in order to avoid having to rely on peaker units and a variety of different, you know, emitting resources, and just shave load generally at the sort of the net peak load problem to address that. So, I mean, I guess I would say to you is like, when you say, oh, I'm not sure it's part of the scope of this proceeding, I mean, I think the commission and the statutes and the entire renewable energy transition is in fact relying on customers to understand what load shifting is and do it. Is that accurate?
Well, Paso Electric definitely understands that there's a lot of opportunity here with regards to the amount of load that we could potentially shift from on-peak periods to off-peak periods with the use of price signals. And that's what we're doing here. And that's definitely part of our strategic plan going forward.
So I guess that comes back to my question: is what is the, and you know, this is the questions I'll have for the intervener witnesses as well. Obviously, I mean, you know, how do we move? I mean, how do we get to a place where rather than I use the word anemic, you use the word immaterial, I believe. Why should the commission have confidence that what's going to be proposed here is going to really lead to any change?
Yeah.
You know?
I think what I'm most excited about, there's a lot of things I'm excited about this project, but with regards to your question, there's a lot of the scope of this project with gathering information about how our customers feel about these rates before the pilot, during the pilot, and after the pilot. And I think to your question, we're going to learn a lot about what they like and they don't like. And I'm hoping with that knowledge, we can present eventually in the future proceeding rates that will be built such that we'll have higher enrollment numbers than what we currently have.
What is the target timeline for EPE for mandatory time of day rates, if there is such a thing that exists within the company?
We don't have a timeline where we have set out that we will put mandatory time of use rates out there that I understand that I'm aware of.
In 2104, which I reviewed in the proceeding, because you know I spent in the TEP case quite a bit of time going through hearing examiner Glick's recommended decision there and trying to understand, you know, how the company created its rate structure for the TEP program. You know, there is in fact, Mr. Schichtel produces a document in that case where he has a timeline which shows when time of day rates will be in effect. And it has like a 10-year and a 20-year window. And I won't ask you to like study it, it's not important, but I guess I'm asking you this question about the time frame because, you know, part of the answer to the P&M application was, you know, P&M's got all these problems with bottlenecks in terms of distribution feeders and integrating DERs, and their advanced metering project is designed to address that. And the answer to the objections that I offered in the recommended decision was, no, I mean, we don't need to delay anything further anymore. And we need to move more quickly and see customer benefits realized. And so the reason I'm asking you this is if customers can actually use advanced meters to save money through time of day rates, when will EPE's customers have the ability to save that money?
Okay, understood. So as outlined in the pilot, we're thinking about running it. We'll run it for at least a year, possibly 2. And you'll see in the testimony of Mr. Carrasco, the average bill savings for those customers that change their behavior and don't. So that I think that may be helpful as well. But after that process is done and we evaluate the analysis, then my expectation is that we would come out with a jurisdiction-wide offering for our customers. We'll have to see exactly what that offering is, depending on how these dynamic rates pilots work out, which pilots are better than others with regards to meaningfully moving on-peak energy to off-peak. And we'll make that proposal then. Will that proposal be a mandatory, as you say, or optional? That's yet to be determined. But long-term, I would agree. I think that's where a lot of utilities and areas are headed towards.
But at this time, there's no target date. I just want to make sure I understood your testimony as to when specifically EPE will propose mandatory time of day rates, if that's even a consider. I guess what you're saying, number one, the first answer is we haven't decided yet that we're going to have mandatory time of day rates. And then secondarily, you're saying we haven't identified a time when that would in fact occur. Have I just restated your testimony accurately?
I believe first we study the pilots, then we make a recommendation. I think it's a little early to make that exact recommendation, but that recommendation, I believe, will be a jurisdiction-wide rate offering. Now, will it be mandatory or not? Again, I think that's yet to be determined. That's a couple of years away. And it may be that it is, and maybe that it's not. So it's just, I can't make that determination right now before the pilot commences.
One of the things I wrote in the recommended decision on the PNM grid mod case as well was, part of the application, these advanced metering projects and time of day rates, these are not new technologies and these are not new proposals. Many utilities have these. If you go back and look at secondary literature, you find that, with California, some of this was occurring in 2006 when they were transitioning over to advanced meters. And it left me with a question, which is just basically like, why do we need pilots to study stuff that we already understand pretty well?
Yeah, first I would answer in that here we are doing it as a mandate from the final order of the stipulation of the AMS case to do this exact scope of work. So, I mean, that's what we're filing this exact set of pilots based upon that requirement. And second, I would say even if there wasn't a requirement, every geographic location is slightly different with a different type of mix of customers, economic and sociographic makeups that make them slightly different. And many times you can glean things from other areas, and I think it's important to do so. A lot of times it's important to look at your own area.
Yeah, and I was reading the Brattle Group's document that they produced, and it was included in testimony here. The one thing I didn't see, and I know this just from previous cases we talked about, the number of customers in the EPE service territory who are, socioeconomically challenged is pretty high, roughly half. And I'm wondering, when Brattle was doing their analysis and coming up with the proposals, did they account for EPE's customers' unique backgrounds?
I would say so. They received a lot of inputs from us, and that input is load requirement information. And when you look at energy or demand usage by your customers, although it doesn't expressly say if they're low income or not, you'll see maybe lower usage patterns on residential groups than you would see in other areas. As a result of that, obviously it could be as a result of other issues as well as with regards to end use appliances like refrigerator versus not. But one thing I would point out is one of the treatments we're seeking to get approved today is our low income residential 2-period time of day. So we are specifically targeting a treatment just for our low-income customers to better understand them because we know how important that is.
And I have just a number of questions for you really that are just purely logistical questions so that I make sure I understand how this is going to work. So you're gonna, and I'm just gonna walk you through it, and you can correct me at any stage if I start misstating how this is gonna work. So jump in and be like, no, that's not what we're doing, if you have to. So the first step here is to market the existence of these programs and this time varying rate and identify people who are interested in the programs, right?
That's right.
And that's going to be purely voluntary. There's no, you're not going to force anybody to participate in this program.
That's correct. We are not.
Okay. And so you're assuming then you'll get so many people will respond, and then a certain percentage of them will actually end up participating. So you have to kind of cast your net pretty wide, right?
That's right.
Okay. And so once you have people who you have identified who want to partake in this experiment, if I understand correctly, they will be assigned to one of these rates and treatment cells, or do they have a choice of some kind?
I believe we're looking at assigning them specifically to a specific treatment.
Okay, so and when you're assigning them to a particular treatment, you're not basing that on sort of an expressed preference of some kind. Like I like the idea, like I'm just kind of putting myself in the shoes of a customer. Hey, this critical peak pricing sounds kind of cool. I want to do that. Like the customers don't have the ability to do that, right?
No, my expectation is that they won't. We'll be targeting treatments one at a time and filling them in as we go. And
okay,
that's correct.
And then so once you've basically randomly assigned interested customers to all the varying treatment groups, you sort of let it all play out, and then the idea is you're going to capture which of these particular rates is most effective. Is that the idea?
Well, we'll capture the information for each of the rates with regards to how well the price signal worked with regards to moving their energy and demand from an on to an off peak period. And that's where that low impact evaluation report and analysis will be very important. So we'll perform that for everybody.
And if I understand correctly, if at any time a customer decides like, this is going haywire, I'm not interested in this is more work, right? I can't change my energy consumption, they can back out at any time, right?
That's correct.
One of the questions I have, and maybe this is a Mr. Carrasco question, I don't know, but I'm going to ask you, Mr. Novella, is all of this business about hold harmless provisions and concern that ratepayers may have a negative experience if this project doesn't proceed in a certain way. I mean, one answer to that, it would seem to me, is one of the things the energy transition is doing is making clear to customers, like, here is the cost of your energy consumption. They're removing sort of all the invisible costs that are hidden through emissions and blah, 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 the free rider effect. And the customers are finally having to confront, like, well, this is actually more expensive than we realized when we're actually asked to pay for everything that this consumption causes. And maybe there's a view that says, customers need to begin to change their behavior. And if they don't like it, that is just too bad. Why isn't that the guiding principle? I mean, why not just say, customers, you're going to have to shift load in order for the energy transition to work, and we don't really care if you don't like that. You're going to have to participate because that is in fact part of the cost of your service. What do you think about that, Mr. Novella?
Well, our original filing didn't have a hold harmless, for the reason that when you have a hold harmless customers can behave different than those that do not have a
Right.
hold harmless. It can affect the external validity of the results as you extrapolate it to a broader population. And through the back and forth and settlement, I think we got to a place where we still are maintaining the integrity of the data by not having a hold harmless that say spans 12 months, but limited to only 1 month, I think provides the protections that staff and others are comfortable with. And at the same time, I'm comfortable with that isn't doing that, you know, and negatively impacting our final results. So I think we landed at a good place.
Yeah, I mean, the distortion impact is one thing, and I understand that the idea that it would skew the outcome. But I just think more broadly, and again, it might be a question for the interveners, witnesses, really, as I'm engaging this conversation with you. You know, yeah, go ahead.
Just my overall view is that ultimately, though, I would agree in the future, as people understand the rates better, you have to take those steps where there will not be a hold harmless provision. So eventually that's where we'll end up getting to.
Right. I mean, I kind of, it sort of struck me as, why not you just rip that Band-Aid off? Do not ease in, just do it. And I think the idea was, at least I saw in several places in testimony, this idea of rate shock. Well, I mean, in some ways, I think that makes some sense, but not in the sense of like, well, now that you're asked to really confront how much is your energy cost to provide to you. And I'm not suggesting we hit it entirely previously, but like all the emissions questions were, I mean, that's the nature of the energy transition. I don't know. I'm just sort of talking frankly at this point. How many customers are currently enrolled in EPE's time of day rates?
I'm not sure. That'd be a better question for Mr. Carrasco.
So your proposal in this case, as I understand it, is to seek commission approval now of the roughly $1 million in expense associated with this project, and then to seek approval in the rate case, that's just kind of the nature of my question one anyway, in a future rate case to collect these costs through rates. That's the proposal here?
That's right.
So I guess the one question I have to you is the idea that you're getting approval here mean that in a future rate case, the discussion of the reasonableness of these rates is a foregone conclusion, or the reasonableness of these costs?
That's my understanding, that here we'll get a approval on the reasonableness of the cost. If there's costs that go beyond that of the roughly $1 million, as you noted, we'll have to present and request that in that proceeding.
Okay. And the question I have is, did the company consider collecting these costs through the rider that you've, I believe, I've reviewed the stipulation on 21-269 in the final order there, and I believe there is a grid mod rider.
Yes, I believe when I read the grid mod language, that the company has the ability to either recover in a rider or in a future base rate case proceeding.
And in this case, you're seeking to collect the cost in the base rates. And the question I'm trying to get at is, in the P&M case, I had all kinds of arguments about what the rider should or should not include, and should we have the rider, and where do you appropriately collect these costs? So from the commission side of the ledger, what I become sort of just swimming through is, all right, so here's some costs that are going to go into rates, but then there's some other grid mod, and you guys are bringing this particular application under the grid mod statute, but then there's other stuff that's grid mod oriented that's going into the rider, and how are we making sense of what's going where?
Well,
does the company have a position on that at this point?
Yeah, I'm not an accounting witness, but my understanding is just through accounting and tagging of different work orders that we're comfortable that the proper cost will be allocated to the proper buckets.
I guess one sense was like, why can't all grid mod costs, like in this case, just go to rates? I mean, that was in fact the argument, one of the arguments in the P&M case. I mean, here you're asking for collection through rates, and seems like the company's cool with it. Does it make the difference when the costs are more? I mean, is that the idea that since it's a relatively small amount of money, you're okay effectively carrying the cost until the rate case is filed?
I believe it's just, we thought it was cleaner, given the type of work and the amounts, just to seeking a base rate case proceeding.
Yeah, the Attorney General's office in the P&M case made that exact argument as to a lot of the P&M costs. And that question about, I mean, the legislature authorized EPE to collect these rates through riders, which gives you a more immediate return, and it's responsive to changes, I think. All right, well, I understand your answers to those questions. I understand it's $1 million. That's not a lot in the utility world. But do we have any idea what the bill impacts of these expenses are?
I'm not familiar with that. No, that might be a better question for Mr. Carrasco.
Yeah, I mean, I wouldn't be surprised if he told me it'll be nominal. All right, here's Emma Crankham. I'm going to stop there. I have to sort of sift through Mr. Novella's testimony and just review that. So I'll let you have an opportunity to pass the torch to you.
Thank you, Hearing Examiner Ryan. And good morning, Mr. Novella.
Good morning.
I have some questions for you. They're going to be more related, I guess, to the details of this pilot and how it will work. Just some clarification questions based on the stipulation, and then some just overall questions about the pilot. I guess let me just start with asking, this pilot is predicated on the rollout of AMS in EPE's service territory. Is that correct?
That's right.
Can you give us an idea of what the current status of that AMS rollout is? I remember I had a case with EPE earlier in the year in May, and I think they told me it was about 45%. I'm not looking for an exact percentage, but can you give us any idea of, how that is coming along?
I can't, Mr. Hearing Examiner, I apologize. I don't know that, but I can't say that it's going well. I went to a meeting recently where they touched on it, and they were talking about that they've been moving along quite well at a good pace.
Okay.
All right, yeah. So let's Hearing Examiner Crankamp, let's do that at the bench request, because that's important.
Yeah, we'll consider that bench request 1.
Yeah, sure. just an update on the rollout of, and for the benefit of our co-reporter, AMS, there's all kinds of, grid mod is horrifically filled with jargon and terms. So advanced metering system. The P&M context, it's advanced metering infrastructure, which you see elsewhere too. So that's the AMI, effectively referring to the same thing. So yeah, so I think the commissioners I wouldn't be surprised if they wanted to know, like, well, how is the rollout going for their advanced metering? How many people are having it? And I think to the extent to which the company can supply, in this case, just an update, that'd be very useful. Go ahead, Hearing Examiner.
Thank you. Mr. Novella, sort of related to that, I am admittedly a novice when it comes to how AMS will work. But one of the aspects of AMS that I understand just from my passing familiarity with Hearing Examiner Ryan's case is that it's possible for customers or ratepayers to actually have some sort of an app or some sort of an ability to see their electricity usage. And that's part of the feature of what some of this can do. And my question was, with respect to this particular pilot, will the ratepayers or the participants in this pilot have some sort of an app or some sort of a way to actually see their electricity usage? And can you describe what that will look like? And then, not to throw another question on there, but does it depend on the treatment cell?
Yeah, that's a good question. So they're not going to get anything special with regards to a personalized app for the participants. But my understanding, and again, I'm not in that area, so I'll kind of keep it high level. We are getting a lot more information as a result of this technology, whether you are seeking it or not. And for example, I just got an AMS meter, and I'm getting a weekly email about how my consumption compared to the previous week. I didn't seek it. It's pretty interesting and informative, but I do have the app, and when I look at the app, I can see interval information that you couldn't see before. So you could actually see your interval information, and I'm not sure the time periods that they allow you to see, but it's pretty informative, and our participants will be able to have access to these apps and access to that information.
Okay, well, that's helpful. And my understanding is that because you have a control group, the control group's access to that data would be the same as your participants in these actual rates. Is that correct?
That's right. I think
Okay.
the differentiation would be that the control groups would be participants that don't get the treatment. So then you could compare the two against one another, but they would have access to the same type of app.
Okay, sorry, let me just follow up on that question.
Yeah, I have a question.
In
about that too.
the PNM case, right, they refer to their the portal through which customers receive information about usage with the benefit of the interval meter as the Customer Energy Management Platform, or CEMP. And there what became clear is that there was arguments about how fast should everything be rolled out, and how many meters should go out, and the answer was, well, if you just require us to produce all of this background technology that allows us to read these, to display the information to the customers, to have the communication networks, but then you don't give them meters, you sort of have created all this technology without providing the meter to the customer, which is the thing they need that's most useful to actually get them to change. And so I'm telling you all this to make the point of, like, it would seem you have to have that portal for the folks who participate in this, whatever you guys call it, in order to, give the customers the opportunity to reflect on their consumption habits. Like, they have to have it, right?
Mr. Hearing Examiner, I apologize for the interruption. I'm not sure if Mr. Novella is aware of this, but we do have, EPE has a motion that's been pending before the commission for several months, seeking approval for the green button Connect My Data portal. And I think that was another aspect of the AMS stipulation. As far as I know, the commission has never acted on that motion, but it is pending before. But so I just wanted to throw that out there. I'm not sure, because Mr. Novella was not part of the AMS case, so a lot of this stuff he may just not be familiar with.
That's fine. And I mean, Ms. Olson, it's fine for you to answer as company representative as well. I mean, it just strikes me that, in order for a customer who participates in this program to be able to reflect about energy consumption and shift load and do all this, you have to have that capacity to inform them. Well, here's your usage, and so that's really the question. It's, I mean, we're going to have that, right? I mean, like, your EP's customers will have that ability, because otherwise they can't really be expected to do anything. Right?
Yeah, and I think a lot of the questions you're asking are certainly things that were raised and resolved in the underlying AMS filing. And then as a result of the final order approving the stipulation in that case and approving the EPE's AMS project, there were a list of several next steps. But I think what you're talking about is, in fact, part of EPE's of the rollout for AMS, and EPE, pursuant to the requirements in that case, has been filing annual compliance filings, providing the information on the percentage of rollouts, the number of customers, where they are in respect to the number of the implementation plan. I think as of April, they were at 123%, which means they're going faster than they had initially represented to the commission. We can certainly get you that updated information per the bench request. And then the AMS platform, as Mr. Novella mentioned from his own personal experience, has ways for the customers to access their data. And then I believe the Green Button Connect, assuming the commission eventually acts on that motion.
What is the case number? Just tell me, what is that to the motion?
I believe that motion is filed as a compliance filing in the AMS case, so it's 21-00269 UT. And again, it was filed in that manner pursuant to the parties' stipulation. And then under the stipulation in the old case, in that case, EPE was ordered to consult with the other stipulating parties and stakeholders for a period. The stipulation lays out the timing to develop these specific pilot rates presented in this stipulation as a means to kind of make meaningful use of the AMS. And so it's an opportunity to investigate. And then the stipulation in that underlying case also lays out the next step, which would be to evaluate the data and present that in the next, it lays out a kind of contingent timing because EPE doesn't know when it's going to file its next rate case, but either as part of a rate case or a standalone filing, depending on the timing of that. So that's all.
Is that the mandatory rates part of this is what you're talking about? So after the pilot?
So, yeah, I think there's probably a little bit of confusion because you're talking about mandatory time of day rates, which kind of relates to EPE's current time of day rates, which has really nothing to do with AMS meters because those rates were in place before AMS rolled out. And then what we're doing in this pilot program, and Mr. Novella, of course, can testify on this, but is to look at, hey, now we've got AMS. What are the additional capabilities that EPE could do in rate design? And that was the agreement in the underlying stipulation in the AMS case was, okay, we're going to approve AMS, but EPE now needs to investigate what that means and what you can do with rates, because you're saying AMS has benefits for rates. And so that's what we're here for today, not EPE's underlying time of use rates that are already in place, but investigating the new things you can do. And of course, Mr. Novella and Mr. Carrasco can say the technical parts of that much more eloquently, but that's kind of the lay of the land from a legal perspective.
Yeah, that's fair. And I understand. I mean, the time of day rates themselves, they do exist and they are there if customers wish to utilize them. And perhaps ultimately, I always sort of had this thought in my head, well, why can't the companies just offer time of day rates without the technologies and just, because AMS is expensive. I mean, 170 million of PNM's $344 million proposal was just for the meters. So, but I think the answer is the limited response from what sounds like in New Mexico customers and Texas customers is that you have to have the capacity to present the information to the customer in order for them to do something with time of day rates, right? Until that exists, it's you're just hoping someone will be very, very proactive because they just don't know. Apart from just reflecting on their, this is when I generally use electricity. Anyway, all right. So sorry, hearing Examiner Crankamp, back to you.
Mr. Novella, I want to take you back to the answer that you just gave to my last question. I was asking you about control groups, the control group on this pilot, and their access to the same type of data that the actual folks in the treatment cells would have access to. And I believe what you said was that The differentiation is that the control groups are the participants that don't get the treatment, so you can compare the two against one another. Is that what you said?
That's right.
Okay, perfect. And so that moves me to my next question, which was I was going to ask you about the control group and sort of the scientific method behind this. So one of my questions was, are the customers in the matched control group, are they volunteers, or are you just essentially just looking at the data consumption of folks who haven't necessarily volunteered for the program?
Yeah, there's different methodologies and ways to do it. You could look at customers that aren't even participants, but are within the same type of subgroup. But I believe these will also be looking at people that actually choose to participate. That'll be part of the load impact evaluation that we're going to produce post-approval. And now exactly which method we're going to go, I'm not exactly sure of those two.
Okay. All right. Well, let me ask you about that. One of the questions that I had, there was a reference in your direct testimony to incentive payments for the participants.
That's right.
Do you recall that? Can you tell me how much are those incentive payments per participant?
I'd have to check my testimony. Give me a second.
Okay. I don't remember seeing an exact figure in your testimony, but it's possible I missed it.
I'm certain we provided it in discovery. I don't recall if we gave the detail in my direct or my supplemental. Let me check. It may not be.
I mean, if it's simpler, I mean, one way to handle that, because the exact dollar figure for my purposes during this cross-examination is probably less consequential. We could just phrase that as a bench request.
Yeah, I'd be happy to supply that. And generally,
that should be
around the $50 mark.
Okay.
A payment before and a payment after, a bit more for small general service than residential. So I believe it's 50 and 75, but we could get you the exact amounts in a bench request.
Okay, that sounds good. So Ms. Olson, let's consider that bench request too, the dollar amount per customer of the incentive payments. And so, Mr. Novella, where I was really going with that, I mean, I am curious to see how much you're offering folks. I figured it would be somewhere in the range of $50, but my question to you are, one of my questions are, what type of conditions are on those incentive payments? In particular, you've talked about it in your testimony, you mentioned it today, that these folks who they enroll in the program, we're expecting an attrition rate, right? Not everybody is going to finish the program. Some people aren't going to, I suppose, have a great time with it. With respect to these incentive payments, do the participants actually have to complete the program, or if not, how much time in the program do they have to spend in order to make sure that they essentially get to keep the incentive payment?
Understood. So they'll be getting a partial payment of that incentive right out the gate, so at the beginning. And if they finish it, the pilot, and say at the end of the 1 or the 2 years, they'll get the second half of that payment. If they if they don't complete it, they won't get the second half, but they'll all get at least half of that incentive payment right at the beginning.
Okay, so again, just hypothetically speaking, if it's $50, they'll get $25 when they enroll in the program, and then another $25 if they finish the program.
That's right.
And then somebody who, let's say, they enroll in the program and they get a couple of summer bills and they have a panic attack and they drop out, they would not get the additional $25, but they would get to keep the original $25 for
That's correct.
in it. Okay.
And I'll point out they'll also benefit from that stipulation item for that 1 month hold harmless. So they'll also be able to bill at their standard rate.
Yes. And
I'm sorry. 1 month hold harmless. And then what was the last thing you said?
So they will be able to be billed at their standard rate.
And my apologies for that, Ms. Gonzalez. That was my fault. Okay, so let me ask you then about the hold harmless provision, because I have some questions just about how that will work. So I understand this 1 month hold harmless provision in the stipulation. My first question to you is, Is that 1 month during the entire pilot or 1 month per year?
During the entire pilot. So that would be that month in which they decide to leave the program. So once they take part in leaving the program, that's it. That's the one time that they get that opportunity. So they can't leave the program and then join again a couple of months later. So it's a one-time offering.
Okay, I guess so. Then let me just put a finer point on it. I guess my question was, let's say you extend to a second year, and a participant stays through the program for the full 2 years. Based on your last answer, do they have a hold harmless month for those 2 years if they stay enrolled in the program for the full amount?
They'll have the opportunity to leave the program and have one hold harmless month during the pilot period. Say if we go from a 1 to a 2 year and they stayed in the 1 year, in the second year, they'll still be able to leave and take part in that 1 month hold harmless if they choose.
I see. So the hold harmless is really only if they decide to leave the program.
That's correct. And then get billed at their standard rate for that month.
Okay. Okay. All right. I see. So the customer has to proactively contact EPE to invoke the hold harmless, and by doing that, they leave then the pilot program.
That's correct. If they choose to leave because of, say, a high bill, and then we'll give them some kind of credit to get them back to their standard rate, and then they could leave the program.
Okay. So then when we say then, as part of the stipulation, and by we, I mean you, when the parties say as part of the stipulation that these customer protections will extend beyond the pilot to the next rate case. In the context of the hold harmless provision, what we're talking about here is essentially that these folks who enroll in the time of day rates would have the ability to be held harmless for a month and essentially get out of the time of day rates. Is that what we're proposing as far as the next general rate case?
My understanding of the stipulation, when it talks about continuum, it points out that it's for section 3.2, I believe, where it's talking about that 1 in 4 summer months. That's another protection in addition to the hold harmless, where we're protecting customers from, say, a very high summer bill and having a limiter. And EP witness Carrasco can, expand on that more than I can.
Okay, so this hold harmless provision is not something that would extend to the next general rate case. It's just really for the pilot.
That's correct. That's my understanding. When we look at the stipulation, it talks about continuing them, the protection, and it specifically points to 3.2, not 3.1.
Okay, I'll have to go through that again. Well, let me pick up on one thread that I just heard you refer to, I think, in terms of the billing demand ceiling, which is the other, I think, customer protection, the whole 1 month out of 4 months thing. You just said the more specific questions about how this will work are maybe better directed to Mr. Carrasco?
That's correct.
Okay. Okay, then I will save those questions then for Mr. Carrasco. Okay. Now, I guess one last question just about the extension of these consumer protections to the next rate case. So, and I guess we're talking exclusively now about the billing demand ceiling. My understanding is that that same consumer protection would extend to all of the customers on the new time varying rate, right? Not just those who were participants in the pilot? Or...
That's right, everybody.
Okay.
And my apologies, I cut you off.
No, I mean, my question essentially was, are these protections for everybody or are they just going to be for the participants? But what I've heard you just tell me is that they would be for everybody who enrolls in these time of day rates as part of the next rate case.
That's right, for everybody.
Got it. Okay. All right. So the next thing I want to ask you about is, and I'm going to try to find your stipulation testimony to direct you. All right. My next questions are about the low-income residential customers in the time of day rate plus CPP plus enabling technology treatment group, which, if it's at all helpful, I think your analysis of this or your questions about this start on page 11 of your stipulation testimony to the extent that it is necessary. I am confused about this provision. So I understand that these low-income customers in this particular treatment cell, these low-income customers are not going to have their own treatment cell. Is that correct?
That's correct.
Okay. So are they going to be lumped in with all of the other residential customers for the purposes of this treatment cell?
That's right. And if I can expand, we are
Please
doing a
do.
separate pure low-income residential treatment for 2 period time of day. As part of the settlement and specifically working with staff, they wanted more information about how our low-income customers, if we could get more information from how they would handle the enabling technology portion, rather than create a whole other treatment, incur additional costs. What we agreed to, and I think it's a good landing point, is we expect there'll be low-income customers within this treatment already that exists. We can tag them and provide a separate analysis to see how did they perform versus those customers that aren't low income. Were there any differences? Are there differences? Just so we could better understand this population.
I see. So we're talking about essentially, we're just looking at a subset of customers within that low income 2-period time of day rate. So they're not being lumped in with the other residential customers.
They're being the low income customers are along with all other customers in the CPP and enabling technologies. We'll just separate them out and perform a separate analysis in addition to our normal analysis, just to focus on these low income customers in the CPP.
Okay. And are you only, these low income customers would be those who already have this enabling technology, right? You're not offering to assist them in, procuring this technology?
So we expect them to already have the ability to have a smart programmable thermostat, but EPE does offer incentives for these thermostats. So we would try to point them to, folks to that way in case they need help in getting those types of thermostats.
Okay. And that offering that EPE has for that type of technology is not through the pilot, it's just through the other activities that the company is doing, right?
Through energy efficiency programs.
Okay. All right. So relatedly, the distributed generation residential customers, this is another one that I found just a little bit confusing. This is another one where there's language in the stipulation and in your direct testimony about the study may not have a statistically valid sample. I was a little confused as to why these distributed generation customers are not going to be in their own separate treatment. Can you flesh that out? Is that just a decision that was just based on cost?
Sure. So originally we offered a program or programs that wouldn't allow for DG customers to participate at all. So that was our original filing. And the reason for that is DG customers are self-producing their energy, as we all know, or at least a portion of it. And when we call these critical events or want people to move energy from an on period to an off period, usually that on period tends to be during the day when they're self-producing all, if not most of their energy. And that can skew results. Ultimately, we landed with, in the stipulation, with allowing DG customers to take part in these pilots, but up to the percentage that they make up of our overall customer base. So, for example, if 9% of our residential customers have DG, up to 9% of our participants in our residential treatments can have DG. We don't want to over sample them, right? Have overrepresentation. So that was one item that we allowed within the stipulation. And then a second item is the one that you just described as we're also going to be looking at them separately, because I just made an assumption that they're going to be producing all, if not most of their energy. So what can they move to an off-peak period? And I think that's something that we want to look at and other parties want to study as well to make sure what if any, can they move? What are those amounts? So this study will help with that.
Okay. Well, so your answer there, I think, is exactly why I'm confused. And I was confused about your answer, if you look at your your stipulation testimony on page 15, there's an answer that you give there. If you look at, it's essentially a paragraph. It begins by saying EPE also did not support an additional treatment for DG customers because the load profiles of DG customers are significantly different from non-DG, such that they are self-producing all, if not most, of their energy during the periods in which the TVRs are designed to reduce consumption. They were not identified as a participant group. So, and that's consistent with the answer that you just gave about how essentially because they are self-producing their energy at the time when essentially the prices would be higher, right? And you just said it can skew the results. In my mind, if it can skew the results, wouldn't that mean that they should have their own separate treatment?
No, I don't believe so. I think the thought is just leave them out to see how non-DG customers behave. But a counter to that is that we have DG customers already in our service territory that make up a percentage of our residential. So let's let a portion of the sample be those types of DG customers, up to say the 9%. So then what happens is that this sample is really representative of our overall population mix. So this is very reflective as we go out and we externally extrapolate this information on a broader population. It'll be reflective of that overall population, where a small subset is that of DG. Not, you don't need a whole separate analysis on DG and incur the cost and the time with increasing or adding a couple hundred sample points on DG to get that information. So I think what we're trying to do here is pull some of that information without increasing additional scope and costs.
Okay. Yeah, I'm still having trouble with that answer, but I do understand, I guess, the point that you're making.
Yeah, and I would say it's very similar to the low income in that sense, where I think we could glean a lot of good information from analyzing a subset, and we don't have to just create a whole new treatment, like an additional low income for CPP. We don't have to create a whole additional DG group, but we can separate those customers that have that attribute and provide an analysis around it. And it would be interesting after the pilot to see how they behave.
Mm-hmm. Well, let me ask you now about the reporting requirements as part of the stipulation. I was interested, there was a line of questioning that Hearing Examiner Ryan engaged you in about the existing time of day rate options. And I understand that may be something that you're not maybe as well versed in, or not maybe able to get into the details on it. But with respect to these reporting options, the question occurs to me, has the company's existing time of day rates, have those provided you with any of the type of data that you're looking to report out from this pilot? I mean, presumably the company must have learned something from, these time of day rates that you're currently offering.
That's correct. We have learned quite a bit, but I think that'd be a better question for Mr. Carrasco.
Okay, I can ask him that. One clarification question that I had, if you look at, let me direct you, page 18 of your, again, stipulation testimony. And this language here mirrors the language in the stipulation, my understanding. One of the items, now all of these reporting items, my understanding, what you testify is that EPE is going to be posting this information on its website and file in this docket a compliance report, right?
That's correct.
So then I guess just a clarification question. One of the items here, if you look at page 18, the effectiveness of the demand charge, there's a clause there at the end that says you're going to be reporting about the effectiveness of this demand charge, including whether customers understood and could respond to the charge prior to obtaining approval for a permanent rate with a demand charge. That phrase stood out to me just because it's a little bit different from your other reporting items. Are you going to be reporting on this at the same time as your other reporting items?
I believe so. I would imagine this would be part of that load impact report, where we could see how those customers in the demand charge pilot did and how effective it was.
Yeah, I mean, I think it would be very useful data. I just wanted to clarify, just because that phrase prior to obtaining approval for a permanent rate with a demand charge is a slightly different formulation of we will be filing all this into the docket
Yeah,
at the conclusion of the pilot.
my expectation is that at the end of the pilot, when we're looking at all this analysis, we're gonna have a lot of information about each treatment, including the demand charge treatment. So I think we'll have a lot with regards to determining whether customers understood it, and also we'll be having those pre and post surveys of customers. So it'd be interesting to see what their thoughts were qualitatively on that same type of subject. So I think we'll get a lot after the project is filed. I'm
Okay.
sorry, after the reports are filed.
And then my last questions relate to, if you go to page 24 of your, again, your supplemental testimony. This pertains to this possible extension of the pilot to a second year. And your first answer there on page 24 says that EPE will evaluate its data prior to concluding the pilot after 1 year and notify the commission via compliance filing if it intends essentially to extend this to a second year. And I was just curious, can you elaborate a little bit on that in terms of what exactly would be the type of data or lack thereof that would compel EPE to extend this to a second year?
Yeah, I think if there's and you said lack, I think right away I want to go to that word. If there's maybe a not enough customers that we were able to recruit and sample, and we want to keep trying to recruit customers. If the pilot started later than what we originally planned for, so say we only were able to get a portion of the summer or a portion of the year, and we think it'll be beneficial to get a complete year, or if its results are somewhat inconclusive, that we need to go to 2 years. I will say that the Brattle group we're working with here would have a preference for 2, but they see a path towards 1 year if the data looks very clean and clear on the results. But we'll have to see if that data comes out that way at the end of 1 year.
Okay. And finally, I was curious about your answer about extending the pilot to 2 years and the possible increase in the proposed cost. Your answer was it's possible that it might increase the cost in that if EPE uses a consultant or a third party to produce or oversee any of the work, there might be an associated cost. And that answer, I guess, doesn't strike me as intuitive in terms of, is that the only additional cost that EPE would have to bear, would be that cost of that third party?
I believe so. I think if we have a statement of work and scope out work for the pilot going out a year and 2 years, and if it looks like, personally, I have a belief in always trying to bring in internally in-house work and not have a reliance on consultants. Just my preference. This is a new type of project, so once we scope the work, I want to get a good understanding of what we can do it internally versus externally, and that's the only cost that I'm identifying currently, that based on that scope of work is seeing what we can do internal versus external.
Okay. Well, that's all the questions that I have for now, Mr. Novella. I appreciate your time and your testimony. Hearing Examiner Ryan, do you want to follow up, or should we take our morning break?
Yeah, let's do the break, because I've been consuming my tea over here. That'd be useful, and I'm sure I'm not the only person.
Okay,
who
that
would
sounds good.
appreciate the break.
All right.
So
well, I've got 10:15. Take a 10-minute break. Come back at 10:25. And for now, we're off the record. Okay, I see Mr. DeSalen. Okay. Ms. Gonzalez, are we ready?
Yes.
Okay, perfect. Okay, we'll go back on the record. And we're picking up with a continuation of the hearing examiner's questions for Mr. Novella. Mr. Novella, I am going to have just a couple, I think, follow-up questions for you, but I know that where I left off was hearing examiner Ryan was going to ask you a few more questions. So hearing examiner Ryan, feel free to take it away.
This is Mr. Carrasco's testimony, Ms. Novella, so you feel free to defer the question to him, but I'm not trying to ask a specific question about what he's saying as much as to the broader plan. Mr. Carrasco lets us know, this is page 11 of his direct. Without a change in usage patterns, residential customers save 35 cents per month. And the small general customer saves at 122. With a load response, the residential class customer average bill impact is 220 of savings per month, or roughly 3.7%, and the small general service 595. I mean, I guess first question is, the participants in this program are not going to know this. These are the projections.
I'm not sure exactly what we're going to share with regards to the detail of their projected savings or bills. So I'm not sure what exactly if we're going to share this information. I need to look into that.
Then my next question is, I'm trying to think about incenting behavior and getting people to do things differently. I mean, the initial problem is, well, if they knew this information, you could then say, well, is it sufficiently great enough of a savings to actually get them to do something? Now, I realize different people in the world have different experiences of $1.22 or $2.20, and I want to be respectful of that. But simultaneously, I do think that that's a relatively small amount of money. Now, if the answer is they don't know that this is what they're going to save, and this only becomes clear to them later, I guess the question maybe you could ask is, will they be satisfied with this amount of savings or having engaged in behavior that means a change for them? So I guess the question I'm asking you most generally is, how did the company come up with these numbers, and as a program, do you think they're adequate?
Yeah, so to your question, yeah, we'll work with the Brattle group to see what they're very particular about what information we will or won't share with pilots based on all the extensive knowledge they have from previous pilots out of the utility. So we'll work with them on that side. With regards to your question about the actual inputs and the analysis, yes, I would defer that to Mr. Carrasco.
But as a general design matter, I mean, why isn't the application for greater savings, the opportunity for greater savings?
I believe it is. I think these are just simply showing averages. So like any average, there could be some on the right-hand side with much greater savings, and that would be my expectation.
Okay. I was going to ask you a few questions about the Brattle Group report. One's a very basic question, which is, in the 2104, if I recall correctly, we went from time of use to time of day. I believe that was the change. And then in this application, we see time of day and time varying rates. Is there any difference between a time of day and a time varying rate?
I believe, and it'd probably be better for a question for Mr. Carrasco, the way I see varying rates is just a wider umbrella that captures more dynamic pricing, like peak time rebates, variable peak pricing, critical peak pricing.
Okay, so when you use the acronym TVR rather than TOD, time of day, time varying rate, you're trying to capture the difference that a time varying rate is more dynamic, like includes the critical peak pricing concept. Is that the idea?
That's correct. I would agree.
Okay. Just give me a second. I'm scrolling to the Rattle Group report. Was the setting of the time of day rate at basically a peak to off peak ratio of 4-to-1 at all driven by the discussion in the rate case, or was that in the 2104 case? Do you know?
No, I do not. That'd be a better question for Mr. Carrasco.
Because one of the reason why I'm asking that question is, in the Brattle Group report, GN George Novella Exhibit 2, page 8 of 48, you have a chart of examples of alternative TVR designs. And in Oklahoma, I noted there is a 4-level, and again, these are acronyms or abbreviations, VPP rate during the summer with a price ratio as high as 8, which is pretty considerable. And so I was wondering, why not something more aggressive in this particular proposal?
Sure. And I believe VPP is that variable peak pricing.
Okay.
That's a very dynamic structure where it's kind of like a time of day, but within one of those buckets of on-peak periods, you'll have the prices change. Really, it could change on a daily basis for events where they really want energy moved from an on to off. So I'm not surprised at that ratio. And to your question, I think we relied on the Brattle Group as well as all the input from the Public Advisory Group. Since it was over a year long, there was a lot of input on what should we study. And
Okay.
ultimately, as a group, we landed on these pilots here.
There's no winter peak in EPE's New Mexico jurisdiction. Is that right? Or no?
That's correct. I wouldn't call it a winter peak. In the traditional,
yeah, go ahead.
No, in the traditional sense, I'm thinking about for cost allocation where I've seen P&M in the past. I don't know if they still do it, where they had part of their 4CP, not getting too in the weeds, where they had a mix of summer and winter or pure summer.
Mm-hmm. Yeah, that sounds right. Well, and I was reading an article recently, I forget where it came from, about managing winter loads as people move to electrification of heating. It doesn't seem like, at least as far as the design of the pilot, that's the real focus is just the summer months for EPE system.
Yeah, that's correct. We're about 80% gas heat here.
Okay. I wasn't sure I understood what this, and I will direct you to the page. So in the Brattle Group report, page 15 of 48. When you get there, there's a generation energy, and it says, after discussions with the EPE team, we determined the company's hourly system lambda profiles were the most accurate reflection of the marginal energy costs. And I was just hoping you could explain what those words mean to me.
No, I can't describe it in great detail, but I will say at a high level, my understanding of it, because this was new to me when we went through this analysis, but essentially Lambda data would bring in market pricing for different geographic points. And we incorporated that information. Beyond that, I'm not informed beyond that on the Lambda pricing.
Okay. We had I think was the last EPE to EP, the several interveners, that's transportation electrification plan for the benefit of our court reporter, TEP. There was a question as to whether or not, and I forget the exact details and it's not important, but the question became whether or not the customer charge could be reduced through off-peak charging of the EV. And the case, in the end, the result of recommendation said no, and the commission approved that. And I see here that the none of these rates impact the customer charge. And I understand why. I mean, I've had the case where we talked about this subject, and I'm telling you that in part because I do get it. But then there's another part of me that wonders, like, why can't time varying rates make impact on a customer charge? Like, why can't it fully reduce your cost of service? And I understand fixed versus variable, blah, blah, blah. But to your knowledge, are there any programs where there's time of day usage will impact customer charge, or is that just conceptually incoherent?
Not that I'm aware of. I think the point of these types of dynamic rates are to send a price signal and get a quick reaction. And since customer charges are fixed, you wouldn't get that quick, you wouldn't be able to send that price signal through that.
And that's all the questions I have. Hearing examiner Camp, so feel free to ask whatever else you'd like to.
Thank you, hearing examiner Ryan. Hello again, Mr. Novella. I have just a couple of final questions for you, if you don't mind. One of the questions that came up in your direct testimony, if you want to turn to page 10. Again, your direct testimony, not the stipulation. You were talking about some of the planning activities that I think would occur after you get commission approval. One of them that's listed on page 10 is the development of a website hosted on the EPE website, only accessible by the pilot participants. Can you clarify what the function of that website is and what information it would contain?
Correct. So it would just be information regarding the treatment specific to the people that we're targeting. So since these treatments are targeted at very specific people, say residential, small general service, we want to be not allow it to be shown to other customers. And maybe these customers want to join, but they can't because they're in another tariff, another rate. So we want to silo it off just to those that can participate.
Got it. So you're essentially, what you're going to do is you're going to create a page on your website accessible only to the actual participants, and it will provide information on the treatment that they are going to be enrolled in.
That's correct.
Okay. That makes sense. My next question relates to page 16 of your direct testimony. And you talk about some of the stakeholder feedback you received from, I guess it was only from the Department of Justice. But in any event, you mentioned that EPE was originally looking at testing peak time rebates. And I know that I saw this in the case that hearing examiner Ryan was referring to. I think it was 20-00104-UT, that there was a reference to to considering the implementation of peak time rebates in the future. And my question to you is, I understand that you responded to feedback from the DOJ. Can you tell me what it was or what that feedback was that convinced EPE maybe not to pursue that, or why these other alternative rate options were superior to that?
Of course. So we were obviously not trying to have too broad of a scope, and we were looking at peak time rebates or critical peak pricing. Actually, we were kind of in between the both of those two options. And after hearing from Ms. Lane from the Department of Justice, she made a case for using critical peak pricing. And I think, we agreed with her that that'd be a fine path to go down. So we were fine with doing critical peak pricing over that of peak time rebates. It wasn't that we were really pushing for peak time rebates. That was just our starting point.
Sure. And I guess I wasn't, suggesting that you were pushing anything. I was more just curious, essentially, what was that substantive feedback? I suppose I can ask Ms. Lane, who's, going to testify later. I could ask her this question. Is that better directed to her?
Yeah, I think so. And then from my vantage point, it's just, okay, do we want to do a critical peak pricing where we're doing these price signals, or do we want to incentivize via a rebate, right? And I think at the end of the day, we're getting to the same thing where we're moving energy from an on to an off peak period, either with a higher price or with a rebate. So I think that's kind of from the EPE side where we were a bit indifferent to the two, but for sure we wanted to include one of them. So after hearing from the Department of Justice that they preferred critical peak pricing, we agreed, just because I think we're getting to the same endpoint.
Okay, thank you. And then my last question, Hearing Examiner Ryan was asking you about the existing time of day rates, and you mentioned that there's been testimony throughout the case, both in pre-filed testimony and then today, about sort of low participation in the existing time of day rates. And you told Hearing Examiner Ryan that that the company has done, and I quote, quite a bit of marketing around these types of pilots. Can you just describe, I guess, a little bit of what type of ratepayer education or what type of advertisement the company has done of your existing time of day rates?
Sure, and I might have misspoken when I said pilots. I don't believe those are pilots, but my understanding and talking to our public relations team, they've done quite a bit of marketing. I've seen little advertisements, commercials. I think they've done bill inserts. I've seen website landing pages. Like if you were to go to our page now for residential rates, I've seen like the top wording kind of promoting our time of day rates. So I've seen them doing quite a bit. And also I will say that we do have a low count, but we've seen a lot of growth. So percentage wise, it'll look impressive where we've gone up, say, from 30 to 120 in a matter of years. So you could say we've 4x'd our count, but the count is still low. But we have seen a good uptick in percentage wise in recent years or months.
Okay. Is that a real count you just gave there?
No, Mr. Carrasco could give you the exact count, but it's in that range. I just can't give you an exact one. Or around the 100 mark. It'll probably be a bit north of that somewhere.
Residential customers?
That's right.
Okay.
Sorry, here's our client. Were you done, or are you?
I'm sorry, repeat that, Hearing Examiner.
I just asking if you were done. I didn't mean I was.
Oh, yes, I was done. That was my last question. I'm going to follow up on that with Mr. Carrasco, but if you have questions for Mr. Novella, please jump in.
Well, one thought occurred to me, and not too long ago, Mr. Novella, we had the abandonment case for it's Newman 1 and I think Rio Grande 7. I think I got those correctly. In any case, that was the hearing on that happened not too long ago, and it was Mr. Wexler was there. And during the course of the discussion, it became clear, like part of the justification for permitting abandonment is there will be, load shedding that will occur in the future thanks to programs like the ones we're discussing today. And I guess I'm just wondering if you have an answer at a sort of macro level, like is EPE targeting in terms of its broader planning how much load's gonna be met by load shifting prompted by these types of time of day programs?
Yeah, so to your question, I know they currently do that with regards to, say, the thermostat program that exists. And they use it in the current LNR, the loads and resources tables that EP produces that you're used to seeing. Now, I believe that these types of pilots aren't in there currently, but as we gather data, I would imagine they eventually will find a home there where we'll be able to provide a scenario at least on future rate design and the resulting impact of demand. And I think that load impact report that we'll produce as a result of this pilot will help with that process.
Okay, that was all. Thank you.
Thank you. I believe that for now, examination by the hearing examiners is complete. I do not see a commissioner on the call. So at this point, I will turn over to EPE first. Do you have any questions, I guess, on redirect here?
I do not have any questions on redirect.
Thank you, Ms. Olson. And do the parties have any questions based on the questions from the hearing examiners? Okay, seeing none. Mr. Novella, thank you very much for your testimony. We appreciate it.
Yeah, I just want to say thank you, Mr. Krankamp. It's a pleasure meeting you for the first time as a hearing examiner. Mr. Ryan, always a pleasure. And I just want to say thank you to the staff witness and the Department of Justice witness and everyone that took part in this case. It's been a long road, but I think us having a stipulation here is a testament to the process, and we all took part in it. Good communication between all the parties, and I'm just very proud of it. So thank you to all the parties.
Thank you, Mr. Novella. That's all good to hear. Okay, well, Mr. Novella's testimony having concluded, Ms. Olson, I believe you can call your next witness.
Yes, EPE would call its next witness, Mr. Manuel Carrasco, and I think we may just need a minute to swap him out there in the witness room.
Okay, not a problem. Do you want to go off the record momentarily? How long do you anticipate?
I'm not sure they're in El Paso.
Let's just take a 5-minute break.
Okay.
Sounds good. We'll come back at 10:53 or so. Okay, I see just about everybody except Assistant Attorney General Elliott. I'm assuming he's with us. Yep, he's back. Perfect. All right, we will go back on the record. And now that we are back on the record, I believe, Ms. Olson, you were going to call Mr. Carrasco to testify.
Yep, EPE calls its next witness, Mr. Manuel Carrasco.
Thank you. And Ms. Gonzalez, can you please swear in the witness?
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you.
Ms. Olson, please proceed.
Good morning, Mr. Carrasco. Can you please state and spell your name for the record?
Good morning, Manuel Carrasco. My last name is spelled Carrasco. First name Manuel.
And what is your current position?
I am the manager of rate research with El Paso Electric.
And I'm gonna turn your attention to your direct testimony, which has previously been marked as EPE Exhibit number 3. Do you recognize that document?
Yes, I do. It's my direct testimony filed March 28th, 2024.
And was your direct testimony drafted by you or under your direct supervision?
Yes, it was.
Are there exhibits identified on the table of contents?
Yes, 4 exhibits.
And are those exhibits part of your direct testimony?
Yes, they are.
Do you have any corrections to your direct testimony?
I do not.
Is the testimony you prepared true and accurate to the best of your knowledge and belief?
Yes, it is.
If you were asked these same questions today under oath, would you give the same responses?
Yes.
Mr. Hearing Examiner, EPE offers EPE Exhibit number 3 along with the accompanying exhibits.
Thank you, Ms. Olson. Any objections from the other parties as to the admission of EPE's Exhibit 3? Seeing none, EPE's Exhibit 3 is so admitted.
Thank you, Hearing Examiner Crankham. That concludes my direct testimony or my direct examination of Mr. Carrasco, and I'll pass him for questioning by the hearing examiners and commissioners if there are any.
Thank you. Again, I believe the parties have waived cross-examination, again, reserving the right to ask questions based on what the hearing examiners ask. So unless any party has a change of heart on that, hearing examiner Ryan, do you have any questions for Mr. Carrasco?
Sure. Mr. Carrasco, when we were thinking about this pilot, I understand Brattle. Well, let's start with that question, perhaps. How much was Brattle sort of driving the design of the pilot?
Yes, I believe that most of the design was theirs.
Okay.
We provided the information that they requested, and they are doing whatever they need to do to get this pilot off the ground.
The question I was going to ask, as having established that, then is, we know there's the TEP rates and there's the EV charging rate, and you have existing time of day rates. And so I just, my sort of general question is, and respond as however you see fit, is, was what the company learned about in those instances brought to bear here? Like, is that happening? Like, I'm not sure if I can be clearer, but is my question comprehensible?
Yeah, I believe that it's not. I think they're just starting a new gathering. They're going to be gathering all the data that they need on a very controlled environment, and they're going to try to do the best study they can for us.
Okay, so to the extent to which, when I asked Mr. Novella about, what's going on in Texas, and you guys have time of day rates there as well. And he, as I understood his testimony, he indicated that there's relatively limited participation. Is that right?
Yes, we have pretty low numbers. They, of course, there are voluntary time of day options, and our numbers are increasing, but not significant levels at this point in time.
Mr. Novella specifically delegated this question to you, which is the cost of the project is, this pilot is about $1 million. And I'm just wondering what that's going to mean. I mean, in terms of rate impacts as paying for this program, I have to assume that's relatively nominal.
We have not studied what the bill impact will be of $900,000. And yes, I agree with you. It's going to be nominal, much less than 1% is what I've estimated.
In your direct testimony at page 6, you explain that the time varying rates in the proposed pilot go beyond the design of EPE's current time of day rate options. And I'm just curious what specifically that means. Can you?
I think the biggest one is, well, first of all, it's a result of a collaborative effort as a result of the AMS implementation. But there's also the other rate options that are going to be studied in this pilot. For example, the critical peak pricing option. It's nothing that EPE has even tried at all. So it's going to be a new thing for our customers, and we'll see how they react. Hopefully, it's to the benefit of both the customer and EPE.
And the inclusion of the demand charge for the residential class, that's the first time, is that right? The customers have been, I don't want to use the word exposed, but let's say subject to a demand charge scenario. Is this the first time?
That is right. It's a new offering for our New Mexico jurisdiction.
And I was trying to figure out, Mr. Novella, like we see here, the projections in your testimony about what the bill impacts will be, both just, with or without load shifting. And I asked Mr. Novella, well, the customers who participate in this program are not going to be told this, like this is really provided just for these proceedings and to give the commission a sense of what could happen. But then the reason I was asking those questions, Mr. Novella, and I'll just come right to it and ask you is, is there sufficient incentives here to produce behavior? Because around $2, if you do everything correctly, doesn't strike me as a whole big lot of savings.
Yeah, those savings that are presented in my testimony are the experience of the Brattle Group. That's what they've seen in other jurisdictions that they work with, other utilities. And Mr. Novella also kind of explained that there's probably going to be like a range of savings and maybe even costs. It all depends on our customers' choice to shift consumption or not.
And they won't know, what the potential outcome necessarily will be of shifting load, just that doing so will help them save.
I think I'm not completely knowledgeable about how the program is going to be promote it to our customers. So I really cannot answer your question how it's going to be presented to our customers.
Okay, on page 12 of your direct at line 21, there's an abbreviation presented. Oh, I think I haven't answered my question in the course of this proceeding, which is the PAG stands for the Pricing Advisory Group. Is that right?
Yes.
And
Well,
I
it
asked
might be
Mr. Novella.
sorry.
Go ahead. No,
It
go
might
ahead,
be,
please.
it might be policy advisory. I'm not quite sure. I can't recall myself.
Okay. I asked Mr. Novella a question about sort of long-term planning, and when I went back and reviewed the documents in the last rate case, Mr. Schichtel did supply a kind of general timeline looking at a broad horizon. And I asked Mr. Novella, what is the company's plans as far as, mandatory time of day rates, if you're going to impose them, and when that would be, and he didn't really seem to know. And I'm just wondering, do you have any further insight on that subject?
I remember that table in Mr. Schichtel's testimony. I don't think that there's any set date as to, okay, it's happening now. I don't believe we have a set date like that. I can't remember which final order EPE was instructed by the commission to return with time of day rates, and not necessarily as more of a opt-out option. I can't recall which final order it was in, though. And I believe that is for our next rate case.
Okay. And is there a projection as to when that will be, or not at this point?
I'm not sure.
Okay. Hearing Zimmer Crankin, that's all my questions for Mr. Carrasco at this time. I might have, depending on what you ask and lines of inquiry, might chime in again, but feel free.
Okay. Thank you, Hearing Examiner Ryan. Good morning, Mr. Carrasco.
Good morning.
I think I want to sort of pick up where Hearing Examiner Ryan left off a little bit with respect to the expected savings, and focus on that, just so that I'm at least clear as far as what we're saying here. You talk about this at some length in your direct testimony, but I guess the simplest is just to look at what you say with respect to the 2-period time of day rate on page 10. And I just want to make sure that I'm conceptually getting all this down. You say here that without a change in usage patterns, the residential customer saves about 29 cents a month, or roughly 5.5% of their bill. So I'm interpreting that as someone enrolls in this, becomes a participant in the pilot, is assigned. My understanding is they're not going to be volunteering for particular groups. They're just agreeing to be on the pilot. They're assigned into this particular treatment cell. If they do nothing, they do not change their behavior, their bill is roughly going to be flat. They're going to save about 29 cents a month. Is that correct?
Yes, that is my understanding as well.
Okay. And, my understanding is that the point of these time of day rates, the point of these time varying rates generally is to incentivize people to change their behavior, their consumption patterns with respect to electricity, right?
That is the expectation, correct.
So if that's the expectation, can you help me understand why we would design the rate such that if they do not change their behavior, they essentially still save a little bit per month? Is the answer to my question that the pilot has been designed so that it's revenue neutral? Is that the answer?
That was what I was going to answer. It is a revenue neutral type of pilot project. Yes.
Okay. And I do want to ask about, again, following up with that same 2-period time of day rate, and the same is true of the other treatment options. You say here that the assumed load response pertains to shifting peak load to the off-peak period, with the residential class customer shifting 9.2%. That is what we are expecting the average customer to do? Can you help me understand exactly when we say that, the assumed load response, what does that mean exactly?
That's from the experience from the Brattle group. That's what they have seen, that customers have shifted about 9.2% of their load from on-peak to off-peak periods. So
Okay.
that whether it happens in New Mexico, customers is the big unknown, right? And that's the whole intent of this study, to see, okay, what is going to be the shift in our New Mexico customers for EPE customers. But the 9.2%, that's just experience from our consultant.
Okay, so just so that I understand, we say that this is the experience of the Brattle group. My understanding then is what you're saying is they expect that if EPE has this pilot program, we have these folks in this particular cell, we expect that on average there will be a 9.2% shift in load. Is that correct?
That's correct.
Okay. Okay. Is there a risk at all? I guess on a conceptual level, one of the things that staff talked about that I thought was, of interest in their testimony, they were concerned about how customers would respond, how they would sort of react to the experience of being in the pilot. Is there any concern at all that this amount of savings, if we expect them to shift their load, they shift it by 9.2%, and the result of their experience is that they see a bill savings of $1.73 a month, $1.73 a month, to be clear. Is there a concern at all that that may not be enough to ensure essentially satisfaction with these rates? Do you understand what I'm asking you?
I'm understanding what you're saying is that, will $1.73 savings really cause customers to really shift their load? Of course, that is on average, right? So maybe our higher consumption customers might have the biggest shift in consumption. All that is the unknown right now, and that's why we want this pilot study. We want to see, okay, what will customers really shift under this time of day options? So that's what we're seeking here in this study.
And I think it's important to just say that, I'm sure that all of the commissioners are going to be very supportive of the plan, and as are, the hearing examiners, and obviously all the parties, they all entered into the unopposed stipulation. I think the concern we have is, you get the case in the future, and who knows what it'll be. But we'll say something like, well, the data from the pilot indicated this, so we did this, and then everyone will go back and sort of look at the pilot and say, well, was that a prudent course of action, and how do we design it correctly? And I mean, there is a degree to which we move forward with this thing. It does, in fact, sort of constrain us in the sense that we only get the data we get, right? Like, so however we design it now is what we're going to live with. I think that's the nature of the questions. And I think just to have certainty about, I guess, and listening to your responses, Mr. Carrasco, you're saying, Brattle came up with this. They're really the driving force here. They've done this before, so, trust them. That's what I'm hearing you say. Is that right?
They have more experience than I personally have. We haven't done this kind of studies. And Brattle Group is very well known, very respected. I do not see why we cannot count on the information that they gather, they provide us on what they see occurring within our customer base.
Yeah, the only question I had, and I asked Mr. Novella this, maybe give you the opportunity to chime in if you have any other thoughts, is, you know, New Mexico, sadly, there's so many social indicators where the state falls at the very bottom of the pecking order, right? Like, you know, it's up there with Mississippi and Louisiana in terms of, you know, lots of indicators socioeconomically, and has the Brattle Group sufficiently incorporated, you know, how much a lot of people in the state struggle when they're thinking about these proposals? Any insight on that?
I know they did consider low income in their original proposal, which is in Mr. Novelas' testimony. There is a treatment for low income, and then in the stipulation, there's a little more discussion as to low income. So all that is also based on what the Brattle Group suggested for us that we consider. So I can't speak for them, but I think that there is a consideration as for low income.
And I guess this is actually more a question for Ms. Olson than you, Mr. Carrasco, but just out of curiosity, why is there no witness from the Brattle Group present today?
Hearing examiner Ryan, I think it initiated from, we were ordered to do this as part of the stipulation. We worked very closely with all of the interveners through the process. And so it just was a fairly straightforward filing. But if there happened to be direct testimony with questions about the Brattle Group, we considered that we could bring them in as rebuttal witnesses. And I think probably a fundamental consideration in this is, you know, EPE is very aware and cognizant of costs that it's incurring, and that ultimately a lot of that cost will be incurred by customers. And so having them participate as a consultant in the design is one thing, having them be available and having to testify in a hearing will just increase that cost. And if it's not necessary because Mr. Novella and Mr. Carrasco were present for the advisory group meetings, as were a number of the interveners, witnesses, and folks at this hearing. So everyone was very aware of the information, and we felt confident that we had enough people to testify to all of that, that it wasn't necessary to incur that additional cost of having the Brattle Group be present to testify.
Thank you. I understand. Hearing examiner Brian Camp, yeah, go back to you.
Sounds good. Mr. Carrasco, my next few questions for you. Let me ask you first about critical peak pricing. I've gone through your testimony. My understanding is that customers will be provided 24-hour notice before any of these critical peak pricing events are called. Is that correct?
Yes, I'm trying to find my testimony and where I talk about that.
Well, I see that you talk about.
Yes, 24 hours.
Okay.
On page 16 of my testimony. Line 9.
And my understanding is that these critical peak period events, they can last more than 24 hours. Is that correct?
I thought that it was going to be a 24-hour calendar hour. Or calendar hour, is that the right word? Just for the time period of that one day. And there's up to 20 days that we can call those on.
Well, one of the reasons why I suspected that it was more than 24 hours, and maybe I'm just not thinking about this correctly, but you say on page 16 of your testimony that EPE can call critical peak period events at any time for up to 20 days in any on-peak period month, limited to no more than 3 events per calendar week. If they were limited to 24 hours, if each event was limited to 24 hours, at that point, then I would be confused by the 20-day limitation. Does that make sense to you?
Well, I think that the notice is going to be given every 24 hours ahead.
Right.
It would be my expectation that if it's 3 days in a row, right, that there's going to be 3 notices sent out for each day.
Okay, so if it's an event that lasts more than 24 hours, then the company will provide an additional notification.
That's my understanding.
Okay. Were the contours of these critical period event were these designed by the Brattle Group?
Yes.
Okay. All right. Well, so one of my questions was, I saw, in the one of the exhibits to your testimony, exhibit MC1, you talk, I mean, the actual proposed rate, and I think this language is similar to the language of the revised rates that is part of the stipulation. There's this reference to the company may call intentional critical peak period events. And the word that confuses me there is the word intentional. Is it possible to have an unintentional critical peak period event?
That's a good question. I would say yes.
So it is possible. So then if it is possible to have an unintentional critical peak period event, what limitations would be present on that? So for instance, as I'm interpreting, and again, this is exhibit MC1 to your direct testimony, page 4 of 5, and it talks about intentional critical peak period events from, can call it at any time for up to 20 days, no more than 3 events per week, all of the sort of limitations that you put in your direct testimony. And then it talks about providing 24-hour notice. If the company can call unintentional critical peak period events, are those same limitations in effect?
As you were speaking, I was like thinking, well, unintentional. I think that requires more analysis here in Examiner. But I know that for the purposes of this study, that it's like a planned event, right? I mean, we know that, okay, we got to call customers 24 hours. And that way they have the opportunity to do whatever they need to do. So I think the unintentional part, I think it requires a little more thought.
I mean, I don't see any reference in here. What's throwing me again is the word intentional. If that word wasn't there, I would have no concerns about this. It's just, you know, as an attorney, I see a word and want to know the impact of that word when we're talking about people's rates. Maybe it's not an issue to worry about. Let me then pivot.
Well, like, but hold on a second. Let me just, before hearing Examiner Ken, let's just try to do this. Mr. Carrasco, could you give us a few examples of what would be an example of an intentional critical peak pricing event? I'm assuming that, well, I don't want to assume anything. So just, can you just tell us like what it would be like, how would the company identify those and plan them? Like what criteria go into that?
Yes, of course, this is these events are gonna be called working with our consultant. That way they can guide us as to, okay, how do we call these things? We are expecting that it's gonna be a purposefully to see the reaction of the customers. Can they react if we call them and tell them, hey, we're gonna go into a critical peak event tomorrow. You need to prepare to do what you need to do. I think it's gonna be more just to see how the customer reacts. That's not that's my expectation. I think that's how that program's gonna work.
Okay, so it may not actually be, I just want to make sure if I'm misunderstanding, then correct me, but you may not actually have resource limitations. You might just call them just as a simulated event. Is that right?
I would expect so. I think that's what we're trying to study with the pilot. How will a customer react if there's a critical peak event? That's
whether in fact there is a critical peak event or not. In reality, it's more just what's important is that you call it and then see what happens.
And see what happens. Correct.
Okay.
Hearing Examiner Ryan, now I have some follow-up questions for that. Mr. Carrasco, can I turn your attention to page? This is going to be, again, staying in MC1, now turning to page 3 of 5. Do you see how it talks, the section titled Critical Peak Period Event Conditions?
Yes.
I thought I understood your answer to Hearing Examiner Ryan was essentially that these would be these critical peak period events are being called essentially to test ratepayers. They're not necessarily an emergency or, you know, the grid is severely constrained, but we're just calling this to see how customers will react. I'm looking at this language here, critical peak period events, signal time. You know, there's a paragraph there, and that does not appear to be consistent with that. Can you clarify for me?
Well, yes, that's a better explanation as to how it's going to happen. I would think that it's obviously it's not going to happen in the middle of the night, right? It's going to be during the on-peak period. But that's the whole intent of a critical peak period event, so that, okay, there's this opportunity for a customer to react. This is what's going on. Let's call this event. Let's see what the customer is going to react.
Okay. Let me ask you this. Does you know, the company is going to be gathering data through this this pilot. Do you intend to maintain data on these critical peak period events that you're calling? In other words, when they occurred, why they occurred, how long they lasted? Are you going to keep that kind of data?
That's my expectation that there would be all that data kept. Yes.
Okay. Let me ask you then about, there was a series of questions that I was going to originally ask Mr. Novella about the provision in the stipulation for this billing demand ceiling. Are you familiar with that provision of the stipulation, Mr. Carrasco?
Yes.
Okay. And so if you look at the stipulation, it talks about this is section 3.2 of the stipulation on page 6. It talks about setting a ceiling for the billing demand for one of the 4 summer months. Can you explain to me how this is going to work in practice? I've gone through the language several times, and I'm not sure that I fully understand how this is going to work in practice. So can you help me understand that?
I know there's an example on there, and that's so it all depends on the load factor, the rate classes load factor, and so this customer, let's see, they experience they're on the time of day demand charge option. The system is calculating, and just looking at this example here, is showing that that customer would be billed 10 kW, right? That's what they should get billed. But because of this provision here, we are going to give the customer a break. So instead of billing for 10 kW for this one summer month, we're going to put that cap at just 5 kW. So you're going to get billed for 5 kW instead of the 10.
Right. I understand how that's going to be calculated. One of my questions is there's 4 months in the summer. I'm not clear which of the 4 summer months would receive this ceiling. Can you clarify that for me?
Yeah.
So the questions that I have about this, and we can take them one at a time. First is which month is going to get the protection? Who determines which month is going to get the protection? And when is that determination made? That's what I'm not quite understanding about this particular form of customer protection.
Yeah, I flip pages to rate 48 of the stipulation, Exhibit A. And I'm looking at page 6 of 13.
Okay, I'm there.
And the first paragraph on that page, it does say towards about the middle of the paragraph, that the ceiling will be calculated by the company.
Yes.
And then at the end of that paragraph, it says that it will be for the bill period of first such occurrence. In other words, that the billing KW crosses that ceiling.
Okay, so let me make sure that I'm understanding this. So essentially what we're saying is the company is going to make this calculation for the customer before the summer starts, presumably. And then essentially the first time that the first month that the customer exceeds this demand, that's when the ceiling would kick in.
Yes, correct.
Got it. Okay. And my understanding is, let's say that that happens that very first month. So the 4 summer months are June, July, August, and September. So June rolls around, there's the ceiling, and the customer blows through that ceiling. That ceiling kicks in. For that particular month, you know, they get this slightly lower bill as a result of that ceiling. If they do the same thing in July, same thing in August, same thing in September, their bill is going to go up because they're not getting the ceiling, right?
That's right.
Okay. Hearing examiner Ryan, that's all the questions I have for Mr. Carrasco. Thank you, Mr. Carrasco. I don't know if you have any follow-up.
No.
Okay. Ms. Olson, any questions on redirect?
I just do have a couple of very brief questions.
Please proceed.
Mr. Carrasco, I just wanted to clarify a few things because there's been a lot of question about EPE's existing time of day rates. And then also the proposal for new additional pilot rates that we're proposing in this proceeding. Is that correct understanding?
Correct.
And so just talking briefly about EPE's current time of day rate offerings, do those time of day rate offerings rely on or take advantage of an advanced meter?
No.
So those rates, which were approved most recently, I think in the EPE's rate case, I'm not sure if they've been amended since then, but those were dependent on just the old, I'll call it a dumb meter.
That's right. They're time of use meters that they are capable of recording consumption at different using different registers for different time of day.
And under those rates, EPE just fixes the time periods for the 2 rates that are in effect, and those aren't don't change at all. They're just an on peak and an off peak at set for blocks of the day. Is that correct?
That is correct.
And if EPE wanted to change the on peak period, what would that require when we're talking about the old time of day meters?
That requires our personnel actually going out in the field and making a adjustment at the meter. It actually requires doing technical work on the meter itself.
So is part of the reason why EPE has never been able to investigate before I ask this question, a customer that's on a time of day rate that doesn't have the new AMS meter, just is on the time of day meter, are they able to view their usage other than when they get their monthly bills?
No, they can't. It's a recording at the end of the billing period.
So is one of the reasons why EPE has not been able to investigate customer usage and customers' response to pricing signals that customers have never been able to see their data in real-time usage? Is that accurate?
Yes, that is accurate.
And EPE has never been able to make a kind of periodic adjustments. They have to set a time period or manually go out and change all of the meters to incorporate a new peak period.
That is correct. On our old meters, that was the process involved.
Okay, and so, and I don't think that you were EPE's rate witness in the AMS case, is that accurate? I can't remember.
I was not.
But you're fairly familiar with the rates as the manager of EPE's rate department, correct?
Yes.
And so, to take advantage now of the switch to AMS meters, EPE now has the opportunity to, customers have the option of accessing their data in, I don't want to say real time, but they don't have to wait month to month to access their data. Is that correct understanding of benefit of AMS?
That is my understanding, yes.
And so to take advantage of customers being able to now see their data, and EPE being able to see to monitor customer data, EPE can now propose and study various rate options that test responses. That what we're doing here?
That is the intent of the pilot program, yes.
And how, I'm assuming that you will be involved in the design of future time of use, time varying use, demand response rates. Is that accurate?
Yes.
Why is the data that EPE is gathering in this proposed pilot necessary from a rate design perspective to be able to design those future rates?
I think that will help us understand at what levels we should set our rates. For example, right now we have a 4-to-1 ratio. With this new information, we'll be able to determine whether that 4-to-1 ratio is a proper ratio that we should be setting our time of day rates at. The 4-to-1 was based on other studies from other utilities, but now I think it's time for us to, and the pilot will give us that information as to, okay, is 4-to-1 a good ratio to go with, or should we be adjusting that upwards or downwards?
And I believe the hearing examiners have alluded to, could an EPE have just skipped a pilot and proposed a revised AMI time of day rate? Is that an option?
Yeah, it could be an option, but we wouldn't have the foundation of information that the pilot rate could provide us. So I think that's valuable information. Instead of using empirical data, why not use data that's applicable to EPE and its customers?
And in your extensive experience and expertise in rate design, do you anticipate that having the benefit of that data and information you can gather from the study to incorporate into rate design of a future AMI time of day rate, do you anticipate that would lead to greater customer participation?
Yes, I think will lead to more participation. Just with the customers that we have now, we've seen an increase, an uptick of number of customers that are choosing to go with the time of day option. I would expect that once they become even more informed, that the time of day option based on this pilot rate study will really incentivize greater signing up of that time of day rate option.
Okay, thank you. That's all the questions I have.
Thank you.
Thank you. Hearing examiner Ryan, any follow-up?
Just one question, Mr. Carrasco, and it's a very general question, and I'm not even sure it's if the time of day rate is highly successful, and assuming the pilot establishes that customers are willing to change their behavior and consume at times it's less costly for them. But I guess I'm wondering, ultimately, does from the rate design perspective, do you start to get concerned about cost, like collecting for the cost of service, and do you ultimately need the coupling mechanism to really earn what is necessary to provide service if time of day rates actually work?
That is something that also has to be considered, of course. I do believe that the study will let us provide a better rate analysis as to what levels of revenue on a normalized basis can be expected. So yes, that would be a consideration.
Okay. Thank you.
Any questions prompted by the hearing examiner's questions from the other parties? So DOJ, staff, CCA? Being none, I have no follow-up. Thank you, Mr. Carrasco. Thank you for your testimony this morning. I appreciate it.
Nice to meet you.
Nice to meet you as well. Okay, so I have 11:45. We've gotten through 2 witnesses, 2 to go. I think at this point, I'm inclined, unless hearing examiner Ryan has any concerns, I think it's probably time for our lunch break. I would propose to come back at 12:45 if that works for the parties. And I think
And Ms. Lane will be up next, right?
that's correct. Yes,
Okay,
that's exactly right. And then
great.
I believe our last witness will be Mr. Dunn. So if there's anything else, unless there's anything else, we'll go ahead and break for lunch. We'll come back at 12:45. Okay, I think we have everybody back that we need. Ms. Gonzalez, are you ready to go back on the
Yeah.
record?
Mhm.
Okay, sounds good. Well, we are back on the record. The time is 12:46, and where we left off was the New Mexico Department of Justice was going to call its first witness, Assistant Attorney General Elliott.
Thank you. The NMDOJ calls Courtney Lane.
Ms. Gonzalez, if you could swear in the witness.
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Please proceed, Mr. Elliott.
Good afternoon, Ms. Lane.
Good afternoon.
Do you have in front of you what is marked NMDOJ Exhibit 1?
Yes.
And would you please identify that for the reporter?
Oops, sorry. Is that my direct testimony or direct testimony?
Yes. Okay. And was this testimony prepared by you or at your direction?
It was.
And if I asked you the same questions today as are asked in your testimony, would your answers be the same under oath?
They would.
And do you have any changes or corrections to your testimony?
I do not.
Mr. Hearing Examiner, at this time, I would move NMDOJ Exhibit number 1 into evidence.
Thank you. Just one other question. I don't know that I heard it. Ms. Lane, if you were asked those questions today, would your answers that you gave, would they be true and correct to the best of your knowledge?
Yes, they would.
Perfect.
Thank you.
Any objections from EPE or any of the interveners? Okay, seeing none, NMDOJ Exhibit 1 is admitted into the record.
Thank you. Ms. Lane, do you have NMDOJ Exhibit number 2?
Yes.
And would you please identify that?
It's my testimony in support of the unopposed comprehensive stipulation.
And was this testimony prepared by you or at your direction?
It was.
And are your sorry. And are the questions, if I ask you the same questions today that are posed there, would your answers be the same?
They would.
And are those answers true and accurate to the best of your knowledge?
They are.
Do you have any corrections?
I do not.
Mr. Hearing Examiner, I move NMDOJ Exhibit number 2 into evidence.
Thank you. Any objection to the admission of NMDOJ Exhibit 2? Seeing none, NMDOJ Exhibit 2 is admitted into the record.
And I pass the witness.
Thank you. And once again, I believe the parties have waived cross-examination. So unless any parties have any last-minute change of heart about that, Hearing Examiner Ryan, do you want to begin your examination of Ms. Lane?
Sure. I guess just starting the hearing examiner Kreienkamp we're discussing during our lunch recess. Ms. Lane, we asked Mr. Carrasco to be clearer about the critical peak pricing events, and he indicated that those effectively can be simulated. They don't even though the tariff indicates they are to be called in response to particular events, that these can be made up. Is that what you understood?
In part, yeah. My understanding is the company was going to calculate the specific trigger for these events based on historical peak demand, and based on that, they would assess whether a critical event should be called. I believe I remember hearing as part of the settlement discussions that if it was looking like there weren't going to be sufficient number of peak events, that the company could also call events that aren't actually needed to ensure that there was sufficient data to support whether the CPP rate was incentivizing customers to change behavior.
I'm sorry,
Right, I mean,
I'm sorry, please repeat, whether the CPP rate was.
Providing sufficient incentive to encourage customers to change behavior.
Thank you.
Yeah, and if I was listening, as I was listening to Mr. Carrasco, what I heard him saying was, you know, it's a pilot, there's a small number of participants that are expected. And realistically, you know, this load shifting that's occurring in response to these events is going to be fairly small just because of how many people are actually even placed into this critical peak pricing treatment group. Therefore, it is all effectively a simulation. I mean, that's what I understood him to be saying. Is that correct, or am I misunderstanding?
Yes, I mean, I think it's a pilot. So, I mean, a simulation, the impacts of the customers reducing the load will be real, but I don't think the company is going into these events thinking that they'll avoid like a serious need through the participation, if that's what you're getting at.
Yeah, that's I just, you know, when you read the tariff, you're led to believe that, like, you know, there's a real need for this or something. And that just occurred to me as we were talking to Mr. Carrasco, like, oh no, it is just a pilot. It is just kind of an experiment. And as Mr. Carrasco repeatedly said, what's more important is what behavior you get in response to the calling of them, rather than what does that response actually produce for the company in terms of, you know, stability. Is that right?
Yeah, I think to the extent these events end up being called on days with critically high peak, there could be some benefit, but I agree that the primary driver of this is learnings.
The other question I had, you know, just speaking broadly here, I mean, Mr. Carrasco did confirm that basically this Brattle is, as I understood what his testimony was, and then listening to some of the answers of both Mr. Novella and Mr. Carrasco, there, Brattle really did develop this pretty much in its entirety. Is that right?
Yes. Mm-hmm.
And was it, you know, I thought, right, I asked the question, well, okay, you know, we had the time and day rates established in 2104, and that was a 4-to-1 peak to off peak ratio. And maybe that was, you know, why the Brattle Group's design also was consistent with that. But I also heard Mr. Novella and Mr. Carrasco say, like, you know, really they didn't really bring what was learned previously from the existing time of day rates or the EV TEP stuff and have it, you know, put into motion here. Like, lessons learned weren't necessarily incorporated. And I'm asking that as a question more than a statement. Would that be accurate?
Yes. My understanding is that Brattle used the current data from system to develop the on-off peak periods and the hours of the system peak period. So using the more up-to-date data on the system, coincidentally, it's also a 4-to-1 ratio. But my understanding to your statement is true. I don't believe that there was an evaluation of the existing time of use rates that went into this, which is why it's great to actually have a pilot that will be evaluated to assess whether things like the price differential need to be changed.
So would you say that, I mean, should the commission be like, well, why didn't we take lessons learned? You know, I could see the commissioner asking that question. So what's the answer to that?
Well, I think there's differences between that pilot and what this pilot seeks to achieve. The integration of the more real-time data from the AMS meters will provide customers with more visibility. In addition, the ability to have one of the rates integrated with smart thermostats, for example, and having that ability to create more of a streamlined approach to getting customers to switch from on to off peak. I think these are all very different than what EPE currently has. I think what this pilot is tested to do is sort of like, this is the way going forward that AMS and time varying rates will be working together. So this is the scope of which we should base future rates on, not the existing rates
Yeah.
for.
Which is, from the hearing examiner's perspective, and then not because it was me doing all the work, but, there was so many pages in 2104 on the recommended decision there. And then I can't recall what happened afterwards, but spent on the question of what is the appropriate, peak to off peak ratio. And, there's countless, and it just feels sort of like, what was the point of all of that? I'm not sure that I have a good answer to that, to be honest with you at this point.
Well, you would definitely want to see that level of rigor in your development of your on-off periods and your price differential. The steps that Brattle took to analyze the system lambdas and the different components of the bill, like capacity, generation, T&D, all of that is very important to assess in determining the rates. You wouldn't want to just go in blindly and say, 4-to-1 sounds right. Let's do a 7 peak hour period because longer is better. There really is a lot of analysis and rigor that goes into the development of these rates, and you would want to see something like Brattle did with conducting all of this analysis from the ground up.
Should the commission infer that the company didn't do that previously?
I wasn't around in this topic for that first go around, so I'm not sure if they did that or did not.
I asked Mr. Novella, to just why has the response to the time of day rates apparently we know in New Mexico, and then Mr. Novella and Mr. Carrasco confirmed is the same in Texas. What is the obstacle to getting ratepayers on board with this? I didn't really get an answer from either witness. So do you have any contribution to that subject? I mean, I realize it's sort of a broad question, but.
I mean, I know that marketing and direct customer outreach and education can have a huge impact on enrollment rates. I don't know enough specifically about what that level of activity is with the current rates, but that would be very important going forward.
If that's the case, you may not know the answer, which is fine if you don't. Is the utility, is EPE at this time sufficiently alerting customers to the future existence of time of day rates so that there will be receptivity to them when they come?
I don't know.
It just maybe strikes me that the commission itself needs to perhaps be more proactive. And I'll offer it as a statement, but put it as a question. Should the commission itself be directing the utilities to be actively telling customers, this is your future, just so you're aware before it even comes? We're just telling you now that this is coming. Do you think that's prudent?
I think you can't go wrong with more customer outreach and education, especially about something new like AMS meters, new rates. Anything to get customers thinking about it will be helpful.
if I understand correctly from your testimony in support of the stipulation, basically all of the recommendations the DOJ made here were eventually folded into the stipulation. Is that right?
Yes.
I asked Mr. Novella questions about the nature of the revenue collection mechanism here, and obviously EPE's plan is they have this cost $1 million roughly, and they'll eventually collect them in rates. One of the issues you recall from the P&M case, Shirley, is this question about where do we appropriately permit collection of costs for grid modernization activities. And here's an example where the company is willing to put them in rates. I mean, when I read this, I sort of thought to myself, well, like this sort of casts doubt on the utilities, not that EPE is making it here, but just more broadly for the commission, the idea that it's necessary to have these revenues collected through the rider, because clearly you can do it through rates and it's not a disruption. Is that a fair thing to infer from the agreements here?
So I actually wasn't the witness on that area. In the other cases, that was Andrea Crane. So I can't really speak to that question.
Okay. Well, I mean, generally, you're aware that there is a grid mod rider, right?
Yes.
And the companies, have in fact utilized those to collect costs for grid modernization projects.
Yes.
If the company had proposed to collect this in the rider, I mean, would your view be the same? It doesn't matter, or would you have a different perspective?
I don't really have this is a good pilot to approve. I didn't really assess how the cost should be recovered.
And the actual costs that are associated with this program are in the utility world small.
Yes.
And one of the questions I was reviewing this, Brattle designed the program. The outreach is going to be done, if I understand correctly, from some organization, this Han group. And then I was left wondering, like, is it necessary to outsource all of this? Is that, like, what is it internally that EPE is doing? Was that a concern that you had at any point during this case?
No, it's pretty common for utilities to have marketing firms handle education and outreach for them, and also have consultants design rates such as Brattle did. So that wasn't a red flag for me.
Okay. Just the final question I'll ask you is, I'm sure you heard me say to Mr. Carrasco, I don't think no one wants to be an obstacle to this type of a program. And certainly that's not the nature of the questions that myself and hearing examiner Kryenkamp are here today and why we're asking them. Rather, it's that, this data that's going to be collected is going to be the foundation for something in the future that I'm sure will be hotly contested. What is if the company moves towards mandatory time of day rates, what are those rates? And this data will be the foundation, I presume, for setting them. So, I mean, the question I'll just come out straight and ask is, like, should the commission be comfortable that this pilot's going to produce results that are going to permit that?
Yes, I believe so. And something that is also going to be helpful towards that outcome is the agreement and the stipulation that EPE share its process and impact evaluation scope with the parties to the proceeding. That's where you really get into the nitty-gritty about what data is going to be collected, how might be used, and the fact that we're able to review and comment on that will even better guarantee that there's good results to be used to inform future rates.
All right. Well, thank you, Ms. Lane. Examiner Kreinkip, that's all my questions.
Thank you.
Okay. Good afternoon, Ms. Lane.
Good afternoon.
I have just a few follow-up questions for you. Probably won't take very long. I want to start with a question that I asked, I believe it was Mr. Novella. I asked him about the company's decision, which I guess is the Brattle Group's decision, not to test peak time rebates. And the answer was that I saw in the direct testimony was essentially that that was a decision that was made after consultation with the AG's office. And I think that was a reference to you. And I asked sort of what was the feedback that led EPE and the Brattle Group not to pursue that through this pilot, and I didn't really get a clear answer. So I'm hoping you can tell me what you told them and why, I guess I won't ask you why they decided not to do it, but I'll ask you what you told them was a consideration with respect to peak time rebates.
Sure. So based on the sample size and how many treatment groups they could have, there wasn't the ability to test both of those options. And my preference was for CPP because with a peak time rebate, you could end up in a situation where you're providing the customer with a rebate for sort of an imaginary peak. And what I mean by that is a key factor in the peak time rebate is the baseline for the customer. So when there is a peak event, the customer gets credit for each reduction in energy usage below their baseline. However, that baseline may not reflect the actual system peak. The customer may not have actually contributed to the peak during event. So it's just there's no certainty that you're rewarding the customer in a manner that's associated with its actual reduction in peak demand, whereas critical peak pricing, aside from the conversations earlier about whether it's being called for an actual critical event or not, when fully deployed, the critical peak pricing is specifically pointing to an urgent peak demand forecast the next day on the system. And you know that if a customer was going to consume directly at that peak time, it would be detrimental to the system. So you're rewarding the customer for not contributing to that system peak. And I also think that there's a better signal to the customer with the peak time rebate. You're just giving them a reward. There's no penalty if they consume more during that peak period. Whereas critical peak pricing, there's a clear price signal to the customer that you will pay more if you consume during this peak period, which will increase costs to the grid and potentially create other problems. So I just think the CPP rate there's more like direct causation with the reduction in peak versus a peak time rebate.
Thank you. That's helpful. I recall that in the Brattle Group's report, there was some data as far as which of these different options is more widespread across the country in terms of where what utilities are using. I don't remember it off the top of my head, but are these CPP charges more common than these PTR, peak time rebates?
I also don't remember where there's more of them or not. They're both common. If I had to say, I would say CPP. I've seen more of them, but I don't have data in front of me.
Okay. No, and that's fine. I can go back and pull it from the Brattle report. But with respect to this critical peak pricing, it sounds like you're familiar with how it's been deployed for other utility companies. what is your understanding as far as the duration of these events with respect to this pilot program? This was one of the questions that I was confused about. I'm still confused about it. And do you have an understanding as far as, can this last more than 24 hours? Is this a
No.
24-hour period? What is your understanding of the duration of these?
No, it's a 5-hour event, and the 5 hours correspond with the peak period, which is 2 to 7, subject to check. So the 24-hour part of the equation is the company is going to provide notice to the customer 24 hours in advance that a CPP event would be called, and that event would last a maximum of 5 hours.
Okay, so when we say critical peak pricing, it's built in that we're talking about peak pricing, and then essentially what we're doing is we're taking it even higher because we have one of these, either real in the case of a permanent deployment, or a speculative or a testing critical event for the purposes of the pilot.
Yes, exactly.
Got it. Okay, that's really helpful. So I also wanted to ask you about the pilot's consumer protection in the form of this billing demand ceiling. And one of the major takeaways, one of the major themes that I had, at least from your direct testimony and your stipulation testimony, was this need for the commission and EPE, but the commission to tread cautiously with respect to demand charges. Can you elaborate on that just a little bit more, as far as why that is something that extra caution is needed where we're talking about residential customers?
Sure. Well, the first part of the reason I caution these rates is that customers don't think about their energy a lot. Even if you're on a time of use rate, those are pretty easy to understand. But a customer is not going to be aware of which of their appliances might have a certain demand kW impact on the grid. And if they happen to use their washing machine at the same time they're using something else, that they're going to trigger this extra demand charge. So there's just a lack of understanding amongst residential customers about how their energy consumption can trigger these charges. And as I cited in my direct testimony, there's a lot of studies that have pointed to this, like customers' understanding of like what is demand versus energy. I mean, I think even us in the energy industry sometimes get tripped up over all the terms. So you can imagine a residential customer not thinking about this often, having a hard time understanding why they're getting assessed the charge. The second concern I have with demand charges is if the goal is to reduce system peak, to reduce needed distribution upgrades, costs on the system, demand charges for residential customers don't really address that demand. Residential customers have a more diverse monthly demand. They don't necessarily have their highest demand be the same as the system peak demand that's driving actual costs on the system. So if you're looking to address that, like something like a CPP might be a better avenue. Demand charges are a convenient way for the company to recover a larger portion of fixed costs, which in a state that doesn't have decoupling, that's a nice incentive to know that you'll get more of your revenue requirements collected regardless if energy consumption goes down. So I just think if these move forward into permanent rates, that all of these factors should be considered, and the evaluation should really strive to figure out if customers are truly understanding these charges and if they are actually responding to them.
Can I just ask a clarification question? This is really truly just for my own edification. But the system peak that EPE experiences, what I heard you just say is that individual customers their activity is dynamic and therefore at an individual level do not contribute towards the system peak. But is it wrong to think that the residential class's aggregate behavior is in fact what drives the system peak?
Not necessarily. I mean, maybe if depending on what's happening on an individual feeder, it's much more likely for a large commercial and industrial customer to be having a greater contribution to that system peak.
That would depend on the utility, right? The utilities
Yes,
would vary.
definitely.
And so is the answer is for EPE, their customer type is in fact reflective of what you just described?
I mean, I am talking theoretical here. I didn't do a deep down assessment since it was a pilot, but I just think that that's a key consideration as we move forward into thinking about permanent demand charges for residential customers, that the impact they're actually having in driving that system should be considered.
Well, it seems like it more fundamentally, I mean, and I was trying to make this point earlier with the EPE witnesses. I mean, it just strikes me, you know, and Hearing Examiner Crankamp and I were talking about this over the lunch break. The hold harmless provisions, all of these approaches to assuring that the customer isn't impacted by anything. I mean, is that really wise? Because ultimately we do want customers to change their behavior, right? Like, and why would they, like, if they're protected from all of the choices that we don't want them to make, they're likely going to make them anyway because they're protected. So I'm just wondering how we, you know, it just feels to me like, to use a I don't know, like I'm not sure an entirely appropriate metaphor, but it's like the soft gloves. We're very much soft gloving this, and is that wise? I guess is a question.
I think for the demand charge, it's hard to me to answer this because I don't love demand charges, but I think for the pilot, the protections make sense, and moving forward, I don't think the protections will necessarily, assuming the customer actually can understand the demand charge, should they continue, the customer protections I don't see are so comprehensive that it would water down the signal. So as we the discussion before the lunch break, it's just 1 month where the customer receives, you know, they don't have no demand charge, but the demand charge is less. You know, it would be great to have some sort of coordination with the marketing team if, you know, a customer does hit that threshold that, you know, this sparks something in the system that says, you know, outreach should be given to this customer. Maybe they didn't understand the charge. Like, I think there's ways that you can work with these customer protections to even enhance responses, because it's a teaching moment.
Ms. Lane, let me ask you this. Given your reservations with demand charges generally, do you think there's value in including them as part of a pilot program and gathering data on their effectiveness? And if so, what do you think the value would be?
I do think it's worth testing. I think just to get customer response as to what aspects of the demand charge they understand through the evaluation will be helpful, because I think utilities across the country are looking more and more at these demand charges. So I'm sure this conversation will keep coming up in New Mexico. Maybe the other utilities will put forward a proposal that's similar. So I think getting data on how customers are actually responding to it, do they understand, while being held relatively harmless for the pilot period, I think it's a good exercise to get that data.
Okay. So my last couple questions, I guess, diving more specifically into the consumer protection in the form of the billing demand ceiling that the stipulation has agreed to. My first question is, and I got this answer from Mr. Carrasco, just in terms of your understanding of how this consumer protection would work, again, in the context of the pilot. What I understood from Mr. Carrasco's testimony essentially was that EPE would be calculating each ratepayer's participants' ceiling, and then essentially applying that to the first of these 4 summer months where the consumer's demand charge essentially crosses that ceiling, then they're going to bring it down to the ceiling. And then if that happens in June, and then he crosses it again in July, August, September, nothing happens there. They get the full amount of the demand charge. But for the purposes of June, it gets brought down to the ceiling. Is that your understanding of how it would work?
Yes.
Okay. And so with that understood, that's what we're proposing, that's what the stipulation is going to do. Is that enough in your mind? Is that going far enough in terms of treading cautiously with respect to the implementation of these demand charges, at least for the purposes of testing them?
I think so, because there's also the second protection. Trying to
that they can leave after a month. Is that what you're referring to?
No, specific to the demand charge, it's called the demand billing determination. It's in that the text and attachment A to the stipulation. Apologies, I'm just trying to find the right page here. But essentially what that second provision does is it averages the customer's 3 highest 15-minute periods of peak demand together to produce the actual demand charge. So if in a given month I peak at like 5 kW, 7 kW, and like 20 kW, I'm not getting pinged at that 20. It's going to be an average of the 3. So that's the second way that's built in it's like in the actual tariff.
Right. And
so
was
that's like
that
a second.
Was that a component of the original filing that EPE had filed?
I believe it was.
Yeah, I believe it was as well. That's I wasn't thinking of it necessarily in the context of the stipulation, but I do remember that it was in the original.
So that's like an existing consumer protection that's built into the actual calculation of your demand charge that I think will be beneficial, because the customer that doesn't know that, oh, I'm doing a wash right now, it's going to spike, it sort of lessens that peak by averaging it out across 3 peaks.
Got it.
Just another question real quickly. The things you're saying that the customers don't understand, I mean, we do ultimately want them to understand it all, right? Like that is part of the, I mean, I guess that's part of my question about the soft glove business is like, it just seems in some ways the customers have had the ability to avoid many of the details associated with the provision of safe and reliable electrical service. And then, this was a point I was discussing with the EPE witnesses, but now the energy transition for a host of reasons requires the society to kind of be more attuned to all of it for a whole host of many reasons. I guess that's you answered affirmatively, but if you have anything further to say about the subject, I mean, the goal is to have the customers way more involved, right?
Yes.
And so it seems like they just, if you engage in not optimal conduct, you're going to have to pay for it. And I mean, I think then there's just no way around that. I don't understand what to do anything but that would seem to me to create an illusion for customers that's just not founded in reality. Unless we're talking the subsidization of, but I mean, I can, whatever, you can go back to the PNM rate case and have a lot of discussion about unity and cost of service and cost causation. I mean, I guess my question is, if we need to educate customers, should we be being more aggressive in terms of how we're educating them about their responsibilities? And does the pilot achieve that end?
Yes, we should do as much as we can to educate customers. I believe through the stipulation, the part able to
I'm sorry, you cut
review.
out for me. I believe through the stipulation, the.
Oh, through the stipulation, that will also be able to review the education materials, I believe. So we could provide input into that. But yeah, I think education is very important. Like I, envision fact sheets where it's letting residential customers know, like, these are the kilowatt demands associated with each of your appliances. If you use these two together, you might create a spike, like really hold their hands through the pilot phase because, you're not going to create the change you want in response to these rates unless customers understand how they're using their energy and how it's impacting their bill.
I'm very like inclined not to sort of like personalize any of this, but I mean, so for instance, PNM's pilot, right? Like I signed up for it just to be a guinea pig. I was like, well, customers are going to go through this, so I'll go through it. I'm going to just, and one of the problems I had, allegedly, I was supposed to receive my meter yesterday or Tuesday. I haven't the slightest idea whether I did or didn't, and I received no communication whether that occurred or not. I don't know what my rates schedule is at the moment, and I mean, and I'm supposed to know about this stuff, and I have no idea what now, like what rate I'm on or what meter I have or any of this. And I think on some basic level, I mean, and I also built a house recently, and after my house was completed and constructed, I continued to get calls from the utilities saying, "Hey, we want to give you electric service." And I can just speak from my own personal experience that I find and I don't know if this is fair to extrapolate, and you can correct me if it's wrong. The nature of the communication between the utility and its customers needs to improve.
I'll just speak generally that is, an area that many utilities can improve in. I don't want to speak specifically to any utility in New Mexico because I haven't examined that, but.
Yeah, and I mean, it's one thing to be hyper focused on this stuff because it's my job, but if you're a working person and have a lot of other distractions in your life, the last thing you're going to be thinking about is, what rate system am I on? And like, anyway, thank you.
And Ms. Lane, I think my last question to you, you said something in your stipulation testimony that I thought was helpful, or at least what I interpreted as helpful. If you look at page 7, you talk about the importance of continuing the customer protections after the pilot has concluded into the next general rate case. And you mentioned that customer experience on the demand charge rate without the TVR pilot customer protections would be likely much different than that evaluated through the pilot. And I know that one of the concerns that had been raised originally with some of these consumer protections, in particular, hold harmless, but some of these other ones as well, was we were concerned about the reliability of the data. And so the way I'm interpreting what you say there and sort of how I'm beginning to think about it just in terms of the reliability of the data is that, if through a general rate case, if we're going to continue these customer protections, essentially the data is reliable because we're not testing two different things. We're testing essentially these rates with these customer protections, and that's what we would then potentially be implementing through a general rate case. So the reliability of the data to that extent wouldn't necessarily be a problem. Am I looking at it the right way?
Yes, exactly.
Okay. Hearing Examiner Ryan, I don't have any other questions. Thank you, Ms. Lane, for your testimony.
Thank you.
Any remaining questions, Hearing Examiner Ryan? Okay. Assistant Attorney General Elliott, any questions on redirect?
No, Mr. Hearing Examiner, I have none. I do have one note. I would request to be excused for this afternoon. I have an appointment, hard stop at 2.
Okay. Well, I don't think that's a problem. I mean, I think the general rule is you don't can't object to anything that happens, but this is a stipulation, so I don't think that's going to be an issue. So that's fine, and in my opinion. And any questions from any of the other parties, EPE or the interveners, from Ms. Lane, based on the questions that we've asked?
I do have just a couple of brief questions.
Please proceed.
Good afternoon, Ms. Lane. Nice to see you again. Okay, let me just get organized real quick. So, I think there's been a lot of discussion today, and you were asked specifically by the hearing examiners about participation in EPE's current time of day rates and reasons for the levels of participation. Do you recall that questioning?
Yes.
And I think the discussion you had with the hearing examiners focused on customer outreach, education, and contacts with customers. Is that correct?
Yes.
Would you agree that the customer having access to their customer usage data may also influence their interest in participating in time of day rates?
Yes, I do.
And were you here when Mr. Carrasco was testifying on redirect about the current time of day rates and those being set up with EPE's old metering system?
Yes.
And under that system, customers don't have regular access to their usage data. Is that your understanding?
Yes, that's correct.
And I believe that you were a participant in the underlying AMS case and have also regularly participated through the AMS advisory group process. Is that correct?
Yes.
And so you would agree that the one of the big benefits of AMS that drove this pilot is being able to now look at customers' response as they have access to their data?
Yes.
Through AMS meters?
Yes.
And do you think in your professional experience and knowledge that may in of itself have influence on customers' willingness to join time of use rates?
Yes, having access to that information.
So they can see how what they're doing impacts their utility bill?
Yes.
And on that question, again, based on your knowledge of it and experience, and I believe you work on these kind of cases outside of New Mexico around the country, is that accurate?
Yes.
And based on your knowledge and experience, would you advise waiting to make any requirements about future rates until EPE, the commission, stakeholders have had an opportunity to evaluate data and look at what actually happens in this pilot program?
Yes, especially if the conversation is heading towards mandatory time of use rates, you would definitely want to assess the unique characteristics of EPE's service territory through the pilot beforehand.
And I believe the hearing examiners asked you questions about design of the pilot rates that were discussing here today. And I think your general testimony was that Brattle designed those pilot rates. You mentioned earlier that you were actively involved in the advisory group process. Did you provide suggestions to EPE and the Brattle group to influence the design of the rates that we're proposing here?
Yes, I can't recall exactly what I commented on at this point, but yes, we did respond to initial proposals.
Okay. And then my final question, I think, goes to something that you just said and builds on that. I think you were having a discussion with the hearing examiners on demand charges, and you were asked about the contributors to the peak. Do you know if EPE has any large industrial commercial customers in its New Mexico service territory?
I don't off the top of my head. I have to admit I'm getting my multiple service territories confused with the cases I'm in. So yeah, I don't recall at the moment.
Understandable. And if you found out that EPE did not have large industrial commercial customers, would that influence your answer about the contributors to the peak period?
I think I would stand by my recommendation that that should be assessed before as one of the considerations as to whether moving forward with a permanent demand charge rate.
Can I ask a clarification question on this subject? Because it seems like I just have it's like I'm trying to conceptualize it, and for a long time, demand charges were relegated to industrial or manufacturing or whatever we want to call those folks, because these people, when they did do what they did, they consumed great amounts of power, and that made the need for the system to supply that increased amount go up considerably. And we would say, well, it's fair for you to pay this demand charge because that activity that you're doing led to that capacity increase, which means you're responsible for it. I mean, so let me ask, did I say correctly, Ms. Lane? Is that am I off on what I just said right there?
No, yeah, that's a fair summary.
Okay, so then what I'm wondering is like, so would it be fair to then think, as we think about residential customers and demand charges, and as we move into this paradigm where the net peak load problem is a real thing that we need to address, you know, as the renewables are winding down towards the end of the day, sun stops shining or whatever, you need to shave load. Like we need to make it painful for people to engage in the use of energy during a certain amount of time. And that is conceptually completely consistent with the way we've treated industrial uses. It's just that we're now applying that basic thought practice to the residentials and saying, you have to have some responsibility for this usage that you've grown accustomed to, but we can no longer supply, or we can only supply at a great cost. I mean, what I guess that I'm trying to have the dialogue with you of like, I understand the demand charge and the reluctance, but it seems completely correct on some level.
Well, I think to the extent that a time of use rate is reducing average peak demand, you're getting, you know, a lot of those benefits. My problem and what I think needs to be studied is for EPE's residential customers, how is their peak when looked at together as a whole, how is that coincident with the system peak? If it's not directly aligned, you shouldn't be assessing a demand charge. And, you know, maybe with the grid modernization technologies being deployed, maybe there's a way to look at it at a more granular level. You know, maybe that data can help answer that question more easily. But I just have a problem that if it isn't the average peak of these customers, residential customers driving that system peak, they shouldn't, that peak demand charge isn't gonna get the reduction or isn't gonna penalize them in the way that maybe you hope it would, I guess.
Yeah, I think I understand, but Ms. Olson, I assume your question to Ms. Lane about the absence of large industrial customers is sort of pointing to the fact that the coincident peak is driven by residentials. I'm not going to treat this as evidence. I'm asking you more as a representative of the company. Was that the nature of that inquiry?
Yeah, without making any representations on EP's actual customer base, that's what I was getting at is if you were looking at hypothetically a utility that only had a residential customer load, then clearly the peak wouldn't be attributed to large industrial customer, commercial customer usage. And
Well,
I think
I mean, yeah, and it's just, and again, just as a representative of the company and not as a matter of evidence, it seems to me, my understanding is New Mexico is kind of unique in the sense that we don't really have much industry. Right? I mean, I maybe that's not entirely fair. I have no idea, but like,
I guess if you were to compare EPE's New Mexico service territory with SPS's New Mexico service territory, you would see drastically different
oil
customer
field
bases.
Right. Okay. Thank you, Ms. Lane. These are all really interesting. It's the future conversation, right? That's what this case is about. So good.
Yes.
Any remaining questions, Ms. Olson?
Thank you. And thank you, Ms. Lane. I appreciate your testimony. I have no other questions.
Thank you.
Assistant Attorney General Elliott, any questions on redirect?
No, sir. Thank you.
Okay. So unless Mr. DeSalen or Mr. Friedman has any questions, and seeing none, I will go ahead and thank Ms. Lane for your testimony today. We appreciate it. And I believe you are excused.
Great. Thank you.
Thank you, Ms. Lane.
And Assistant Attorney General Elliott, you're excused as well to the extent you need to leave it, whenever you need to leave. So with that, we turn to staff. Mr. Friedman, would you like to call your witness?
Yes, Mr. Hearing Examiner, thank you. I'd like to call staff's witness, Mr. Christopher Dunn with the New Mexico PRC's Utility Division.
And Ms. Gonzalez, can you swear in the witness?
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mr. Friedman, please proceed.
Good afternoon, Mr. Dunn.
Hello, Mr. Friedman.
Do you have a copy of your direct testimony that you filed in this case, known as Staff's Exhibit 1?
I do.
Is it a complete and accurate rendition of the testimony you prepared and filed?
Yes, it is.
And do you have any corrections that you need to make to this direct testimony?
I do not.
If you were asked today at this hearing the same questions in your testimony, would your answers to those questions remain the same or would they have changed?
They would remain the same.
Mr. Hearing Examiner, I'd move for the admission of Mr. Dunn's direct testimony known as Staff's Exhibit 1.
Thank you. Any objections to the admission of Staff's Exhibit 1? Seeing none, so admitted.
And Mr. Dunn, do you have a copy of the testimony in support of stipulation?
I do.
That's known as Staff's Exhibit 2. Is it a complete and accurate rendition of the testimony you prepared and filed?
Yes, it is.
And do you have any corrections that you'd like to make to this testimony?
I do not.
And again, if you were asked today at this hearing the same questions in your testimony of support of the stipulation, would your answers to those questions remain the same or would they have changed?
My answers would remain the same.
Mr. Hearing Examiner, I move for the admission of Mr. Dunn's testimony in support of the stipulation known as Staff's Exhibit 2.
Thank you. Any objection to the admission of what the document that has been identified as Staff Exhibit 2? Seeing no objection, it's so admitted.
And I will offer the witness up for cross-examination.
Thank you. Once again, the parties have waived cross-examination. Hearing examiner Ryan, would you like to ask any questions of the witness?
I guess just the same question I asked Miss Lane was overall. I take it Mr. Dunn, staff's position here is that the design of this pilot program is sufficient to guide the commission in any future endeavor it's going to undertake to develop rate structures for the EPE in some future rate case. The staff doesn't have any reservations that the data is going to be distorted in some way that's going to make it a trouble in the future. You don't have any concerns about that?
I do not. That's not to say that I would turn a blind eye to, examining future rates and just making sure that they're consistent with rate making principles, with the public interest, and generally are aligned with the commission's goals. But in regards to the pilot, I believe that it will provide valuable information that will inform future rate making decisions.
Yeah, there's nothing that you see now. I mean, this is kind of the nature of all the questions we're asking, really. It's just to try to see what we don't see at the moment. But there's nothing that you're aware of that should give the commission heartburn at this point about moving ahead and seeing what the data shows, right?
No, sir.
That's all for me, Mr. Krankamp.
Thank you. Good afternoon, Mr. Dunn.
Good afternoon.
I have just a few questions for you. The first question I wanted to ask you, I noticed in both your direct and your stipulation testimony that you talked a little bit about the possibility that you're trying to sort of guard against through consumer protections of consumers having, ratepayers having, you phrased it, an overwhelmingly negative experience as one possible outcome for what could happen. And that caught my attention both times. Can you just elaborate a little bit on that concern and how it was addressed through the customer protections?
Certainly. Yeah, I think that, as has been discussed by many parties today, that, the extent to which time of use or time variable rates, we might use different terms for them, time of day rates have been adopted within the New Mexico jurisdiction of El Paso Electric Service Territory to date is somewhat limited. And so, hopefully the educational components and the information provided by the company will help customers to be well informed and ready to participate in these rates. However, we do recognize that, for quite some time, these customers have been on the traditional rates. That's an inclining block rate. And to shift to a rate that is altogether different could take some efforts for them to be able to learn how to best utilize that rate. There is a possibility that, if they are not effective at changing their behavior, that they could have exposure to a higher bill than they would otherwise be likely to incur under their traditional rates. And so under the principles of, avoiding rate shock, promoting gradualism, and just supporting the public interest in general, staff believes that the protection mechanisms provide a means for customers to be able to participate, to be able to provide valuable data to EPE, to allow interveners and all stakeholders to be able to see how these rates are truly going to impact the system as well as the customers, but also giving them a means to make sure that they're not going to be negatively impacted in such a manner that can be, truly harmful to them as a customer, or that might, in the future, if enough customers perhaps were negatively impacted, to create a bad word of mouth about these rates, because we see the value, I think, among the parties to be able to find new ways for our customers to be able to effectively utilize the resources that are afforded to them through the system. But if we don't handle that effectively, then there's potential repercussions that could be negative, and it could make deploying these rates in a broader sense in the future more difficult. And so I think that the protection mechanisms that have been agreed to by the parties in this case help to allow informative data, but reduce the likelihood that a negative impact is going to be significantly burdensome on customers.
Thank you for that. And I think your point about sort of a bad word of mouth was sort of where I was going with that question. We've had this dialogue through the hearing about the point of these time of use rates, these time varying rates, is to shift behavior. And so, as we have customer protections in place that can, obviously that can change or it can lessen the impact of, our efforts to shift customer behavior. But what I got away from staff's testimony is that as important as that is to shift behavior, it's also important to keep in mind the ratepayer experience through these rates. Is that a fair summary of the concerns behind some of your testimony?
It is. And if I may offer a commentary that I thought of whenever hearing examiner Ryan referred to, are we perhaps using kids' gloves here? And it made me think of, I understand that perspective and the guarding against it, but it also made me think of it in kind of the boxing reference way of, well, Mike Tyson said, everyone has a plan until they get punched in the face. And I think for our customers here, they might have the best intentions to change their behavior in such a way that is effective with these rates, but experience can be a great teacher as well. And I think even if ultimately some customers utilize that, for example, that 1 month forgiveness mechanism, that's also a learning point, a data point for us. So I think that it's an appropriate tool to have in our belt.
Okay, thank you for that. One of the items I wanted to ask you about that I don't think we've talked about too much, I think we briefly spoke about this with Mr. Novella, but the stipulations provisions with respect to low-income customers and the time of day rate plus the CPP plus enabling technology, as well as the expansion to distributed generation customers. I think he was the only witness that we've talked about this with. The stipulation talks about, with respect to both of those sort of customer groups, that this might not result in a statistically valid sample, but nevertheless, it still might provide data that would be of some value. Can you elaborate on sort of the thought process that went into, not having those two groups as part of separate treatment cells, and essentially why that was handled that way in the stipulation?
Certainly. I'll state that in my direct testimony, Exhibit 1 for staff, you'll find that I initially did recommend that those be considered under separate treatment types. In discussion with EPE and other parties in this case, I think that it was that we arrived at a compromise that will provide valuable information, with understanding that, if we are going to add to those treatment cell types by, creating a specific DG treatment cell or a specific low income CPP plus enabling technology cell, that we might be getting into scope creep, additional costs as well. And what is it that we're really trying to understand? And so I certainly advocate for us to be able to study and understand the impact to those customers. And that's why I think it's an important component to be able to add them. In coming to that compromise, one of the positions that staff took is that, look, we're not going to have a statistically relevant group. One thing that I don't want to occur is for it to be the case that we say, well, look, we included these customers in our study, but we didn't have the statistically valid sample size for them, so who cares? But I wanted to make sure that we had an ability to be able to point to and say, look, this is still information that should be considered going forward. Maybe it informs us on additional, pursuits we need to take to be able to better understand the customers. But ultimately, I think that it does give us a means of limiting scope creep, of limiting the additional costs associated with, trying to add those treatment types to the pilot program, but giving us a good and viable means to be able to understand the impact of those customers and how they might behave within the context of these rates.
Okay. And then the last question that I had for you, we've had a fair amount of questions thus far about EPE's existing time of day rates. And, I think maybe almost too many questions about that. But I guess my question to you would be, you were, in your testimony, you talked about them having, I believe the phrase was minimal customer participation. Can you testify a little bit more to that and why you suppose that is and what can be done in the future to encourage more participation in these types of rates?
So I can testify that I have reviewed some numbers that looked at the participation in those rates. I believe it was reported as a compliance item in EPE's rate case 2104. And so the numbers are quite low. In terms of why we're seeing that limited participation, it's difficult for me to speak to that because I haven't been a party to other cases wherein these rates have been a consideration, or wherein we've really looked at what are the tools that we're using to recruit customers and how effectively are they performing. So it's difficult for me to speak to the reasons why. I think one of the primary drivers of that would be just momentum. Customers have been on the existing rates for quite some time, so you're asking them to change to something that they're less familiar with, and without a lot of support and just I think effort by parties to educate those customers, it might be difficult to overcome that momentum. And with that in mind, I think that it looks at some of the considerations that have been put forth and been included in the stipulation to look at how the educational materials have been developed, what's the content of those materials, how effective were they, and those things I think should come out in the reporting that we'll have as a result of this pilot program to help us understand in the future, okay, what have we done and what was effective and how can we improve?
Great. Thank you. That's all the questions I have for you today. Mr. Dunn, thank you very much for your testimony. I appreciate it. Hearing Examiner Ryan, any follow-up on that? I think you're on mute.
Yeah, I am. I'm sorry. Just, Mr. Dunn, do you think it's valuable that EPE be out at this time before time of day rates are even, like, what exactly they're going to be is completely unclear, but to be messaging to customers, hey, these are coming in one way or another?
I think there's, as has been articulated by other witnesses, I think that there is value in communicating with customers in general. I think that if this is the road that is likely to be traveled in the future, then early communication can benefit customers. I think that that's likely to be the case, not only in El Paso Electric service territory, but in the service territories of many utilities that are looking to make significant changes to the way that their customers take and receive service and pay for that service. So, I think that being proactive about education with consumers in terms of what is likely to happen, why, and what their role in our energy future is, I think that could be, generally speaking, beneficial.
All right, that's the only follow-up question I had there. Thank you.
Mr. Friedman, any questions on redirect?
No.
Okay. How about EPE or the interveners? Any questions for Mr. Dunn?
None from me.
No.
Okay, thank you both. Well, Mr. Dunn, I think that's everything for today. So thank you very much for your testimony.
Absolutely. Thank you.
And you are excused.
Thank you.
So I believe at this juncture, we have gotten through all of the witness testimony. EPE, do you have any additional witnesses or evidence or exhibits you want to call?
No, I have nothing else for the evidentiary portion of the case.
And staff or Mr. DeSalen, anything further from either of you?
Nothing from staff.
Nothing from CCAE. Thank you, Mr. Hearing Examiner.
Thank you. Okay. Well, with that, I believe that concludes the evidentiary portion of the hearing today. As far as moving forward, I guess we should address briefing. The inclination of the hearing examiners, I think, is just to stick with the default time periods for briefing, unless the parties have any concerns with that or suggestions as far as a different approach.
I would just say that it would be helpful to get some guidance because we have an uncontested stipulation and there was no cross-examination or any contested issues at the hearing. So I would say there's no issues to brief, but if you could give direction and what type of a post-hearing paper might be helpful to the hearing examiners, we would certainly be happy to provide it.
I can answer that question, but yes, Mr. DeSalen, you have your hand up.
Yes, thank you. I want to second, I think, what Ms. Olson said. I'm really wondering, and of course, this is totally at the pleasure of the hearing examiners, but I'm really wondering if there is the need for briefing, post-hearing briefing in this matter, given where we are.
Well, as far as where my head was, I was looking at briefing not because I had specific issues that I really needed briefing from the parties on, but mostly just to give you the opportunity to file that briefing, just because you do have that right under the rules. Hearing examiner Ryan, any thoughts on this particular question?
So if there's no briefs, you could theoretically, or we could theoretically just produce I'm trying to think what you I mean, certification of stipulation presumes, you certify it. So what is the opposite of that? The decertification, but whatever, we'll produce a recommended decision on the certification of stipulation at our earliest convenience and then permit for an exception period.
Yeah, and this is interesting because I think that the procedural rules contemplate a process for stipulation that doesn't, or for the uncontested stipulation that doesn't necessarily incorporate briefings. So that was why I asked. I think in answer to your statement, hearing examiner Ryan, I think the next step is the hearing examiner issues a certification of stipulation with the recommendation, positive or negative, or otherwise suggest a manner of disposition, and then exceptions are filed within 10 days after the date it's certified. So I'm satisfied with that process. But as I say, if there's some post-hearing paper that would be helpful to you guys, I'm happy to do it. I just don't think there's any issues that would benefit from briefing because there's no arguments in opposition to anything.
I mean, I think I'm fine without it. I mean, if the parties are not inclined to file briefing, I don't know that I necessarily I don't know that I have to mandate it. Commissioner Ryan, I'm open on this issue. It's really up to you.
No, I mean, I think it's fine if the parties are willing to. I mean, what we probably should do is just produce an order saying that, just commemorating for the record, saying, well, we discussed the potential for a briefing schedule at the conclusion of the hearing. Parties indicated, given the posture of the case, there was no need for briefing. The hearing examiners will issue writing at their earliest convenience, and parties will have the opportunity to file exceptions. We'll just produce a writing that commemorates that. That's what I would suggest.
Okay. Yeah, we can issue an order to that effect.
And then to the extent to which we do come, I mean, in the process of just sitting down and thinking about this, if we discover anything we need, we can just reserve the right to say, hey, we will give the parties the opportunity to contribute to the discussion to the extent to which we identify anything that needs to be addressed. But I'm largely agreeing with Ms. Olson, and as I've made clear throughout the hearing, I mean, I don't think anyone is interested in standing in the way of any of this. It's just making sure what we're doing is going to be satisfactory to all downstream users.
Okay, so that's how we'll proceed then. We'll issue an order either today or tomorrow, just confirming that the parties have waived briefing and we're not going to be waiting for that. I guess one last issue before we adjourn, just to confirm the 2 bench requests from today. So bench request number 1 was the status of the AMS rollout. And then bench request number 2 was the dollar amount per customer of the incentive payments. Any questions about that from EPE's standpoint?
I don't have any questions. I will endeavor to get that information to you as quickly as possible. Recognizing that we have next week and then Labor Day, could we just ask for a deadline of September 3rd? But I would imagine I can get it to you before that. I just want to make sure that the project manager in charge of AMS, I haven't been in touch with her lately, that she's not for some reason out or unable to get that information more quickly.
I have no problem with the 3rd of September. Is fine.
September 3rd it is. Okay, anything further from any of the parties before we adjourn today and go off the record? Okay,
Nothing from staff.
Okay, seeing none from any of the parties, we want to extend our thanks to all of you for your professionalism today. And with that, this hearing is adjourned and we are off the record. Thank you.
I did want to say this when we were on the record, but because I didn't want to make Miss Gonzalez write it down. But you know what? Wendy's did a time of day hamburger policy. So if you went to Wendy's, and if you went to Wendy's, I think it was Wendy's. If you went to Wendy's at the rush at the noon hour, they charged you more for the hamburger than if you went at like 10:45. All of the Wendy's customers revolted to a point where they had to completely rescind the entire thing. It was pretty fascinating, actually, studying economics, like different thing between electricity and hamburgers, obviously. But I remember one person at the New Mexico State University, they were hiring a new professor there for the utility section. And his interest, I mean, he did a presentation, was on using lessons learned from the utility sector in America's healthcare, which I thought was kind of fascinating. So there's intersectionality in a lot of this stuff.
That Wendy's kicked themselves for not piloting the idea before they rolled it out.
You have to figure out how you recruit your what kind of messaging. Truth be told, I would have gone to Wendy's if I was more motivated for hamburgers, for a cheap hamburger. Anyway,
I have a question. When reference is made to 2104, is that a case number?
Yes.
21-04?
20-104.
20-00104. Yeah.
Okay. Every time I heard that, I wrote 2104. So I'm glad
that threw me off too.
I'm sorry.
I'm gonna correct my mistake.
No, my apologies. It's the commission's convention for case numbering. So the 20 obviously would be 2020, and then the 001. And then why do you have these numbers? Because of the e-docketing system requires you to have the 2 zeros followed by docketing number 104 for that particular calendar year.
No, it's just that how I heard it was 2104, right? So it gets to be a hearing error and a mind reading thing, and I'm not very good at it. So that's why I clarified. So I think that was my only question, but I'll pop you an email if I have any other transcription question.
Sounds good.
Okay.
Well,
thank you.
Thanks
guys.
again, everybody. I'll go ahead and end this and take care.
Nice
Thanks,
to meet
everyone.
you. Bye-bye.